right, I call this meeting to order. First of all, it's a pleasure and honor to be here as your vice chair chairing this meeting. Thank you all so much. Welcome to meeting 37 of the House of Commons Standing Committee on Public Safety and National Security. Pursuant to the order of reference of the House of April 20, 2026 and the motion adopted by the committee on April 30, 2026, the committee is resuming its study of Bill C-22, an act respecting all lawful access. Bienvenue to our witnesses. We have Professor Leah West as an individual. Welcome. We have Chief of Police for Thunder Bay, Chief Fleury. And we have Chief of Police for the Toronto Police Service, Chief Demkew. Welcome to you all. You all have 5 minutes to make an opening statement. For those in person, I will endeavor to try to get your attention when you're at 1 minute, and then when we're coming down to the time. And hopefully I can do that as well for the people that are by video link. With that, I invite Professor West to make an opening statement. Thank you.
Chair, members of the committee, thank you for the opportunity to appear today. By my count, Bill C-22 represents Canada's 9th attempt to enact lawful access legislation. That alone should give us pause. For over a decade, successive governments have recognized the same problem. Our laws have not kept pace with the realities of modern criminal and national security threats or the tools required to address them. The result is a growing gap between Canada's lawful access framework and the central role electronic data plays in investigating and prosecuting crime. At the same time, the Supreme Court of Canada has been clear that even basic identifiers can reveal deeply personal information and are therefore protected under Section 8 of the Charter. As the court recently reaffirmed, an IP address is often the first digital breadcrumb that can lead to the state on the trail of an individual's internet activity. The government and this committee have a difficult task: to address the existing operational gap in a way that is consistent with the Charter. Bill C-22 is a meaningful improvement over past efforts at reform. It reflects the hard work done by officials at Public Safety Canada to engage with stakeholders and revise earlier proposals. It is more carefully structured and, in my view, capable of getting us to a workable lawful access regime, but it is not there yet. Let me briefly highlight 3 areas where targeted amendments would significantly strengthen the bill. First, the Subscriber Information Production Order. The bill introduces a new tool that allows police to obtain subscriber information on a reasonable suspicion standard. In my opinion, that standard is constitutionally defensible, but the bill as drafted goes too far in another respect. It requires service providers to produce all subscriber information as defined, tied to an identifier, regardless of whether each category of data is actually relevant to the investigation. This new power applies to anyone who provides services, not just telephone service providers, creating a risk of overcollection of private information that does not meet the legal threshold set out in the bill. The fix is straightforward: amend the provision to give police the discretion to request and judges the discretion to authorize only specific types of subscriber information for which the standard has been met. If the standard for a production order is going to be suspicion, then the scope of what is authorized must be narrowly targeted. Second, risk to individuals in foreign jurisdictions. The bill allows Canadian authorities to request data directly from foreign service providers. This power is important, but it carries risk. There is currently no requirement for a judge to consider whether such a request could expose the target to mistreatment in another country, and that is a gap. I recommend adding a clear obligation for judges to assess whether there is a substantial risk of mistreatment and to refuse the order where such a risk exists. This would align the regime with Canada's broader human rights commitments and what is already obligated for RCMP officers under the Avoiding Complicity in Mistreatment by Foreign Entities Act. Third, and most critically, Part 2, or the SAIA, which is what I'm going to call it, requiring companies to build interception capabilities and retain data that they would not otherwise keep inevitably creates cybersecurity risks. Every additional access point, every new repository of data is a potential target. The question is not whether the bill creates new risks. It does. The question is whether the bill adequately mitigates those risks and strikes the correct balance between the risks and the public safety imperative. As currently drafted, I don't think that it does. 3 changes are essential. First, strengthen the definition of systemic vulnerability and prohibit the GIC from weakening that definition through regulation. Second, prohibit blanket data retention. I believe the current authority engages the right to privacy as overly broad and creates a significant cybersecurity risk. The current 1-year framework departs significantly from existing 90-day preservation limits, and I've yet to hear a compelling argument for the need for a blanket retention obligation not tied to any specific collection authority or subset of offenses such as serious crime. Any retention regime must be necessary for investigative purposes and must be reasonable and proportionate to the offense or threat under investigation. Third, make explicit that law enforcement and CSIS cannot directly collect or intercept personal information or private information from service provider systems. Control over access to providers' data and systems must remain with providers. They alone should flip the switch. This is critical for privacy, security, and legal clarity. In conclusion, I believe deeply that Canada needs lawful access reform. But the task is not simply to expand access. It is to ensure that any expansion is necessary, reasonable, and proportionate, that it does not undermine constitutional protections or create undue security risks for Canadians. Bill C-22 is a meaningful improvement, but targeted amendments are still required to get this right. Thank you.
Thank you, Professor West. Perfect time. We will now move on to Chief Fleury. You have 5 minutes. Thank you.
Thank you. Chair, members of the committee, thank you for the opportunity to speak with you today about Bill C-22, an act representing lawful access and why policing leaders across Canada strongly support its passage. Policing in Canada has changed dramatically over the past decade. Crime is no longer confined to physical spaces or geographical borders. Today, organized crime networks appear across jurisdictions using encrypted applications, anonymous accounts, and digital platforms to coordinate activities such as drug trafficking, human trafficking, firearm smuggling, and cybercrime. Yet the laws that govern how police access critical information were largely designed before the digital reality existed. Bill C-22 is about closing that gap. It processes practical, measured updates that would allow investigators to access certain information more efficiently, always with lawful authority, judicial oversight, and a full respect for the Charter and the privacy protections Canadians expect. This is not about expanding unchecked powers. It is about ensuring that when police have lawful grounds to act, they can
one
do
moment,
so
please,
in a timely
Chief.
way.
Just if I could interrupt you, please. If you could please take the boom of your microphone down just a shade so that it's not touching your skin, please.
Oh, okay. How's that?
I think that if you could actually just do a test.
If you could just do a test 1, 2 for us, please, just to make sure. It's. I think it's probably hard on the interpreters. So if you could just do a test.
Test 1, 2. Test 1, 2.
Yeah, they're getting.
Yes, thumbs up. Thank you. Sorry to interrupt you.
Okay. No, that's good. Thank you. This is not about expanding unchecked powers. It is about ensuring that when police have lawful grounds to act, they can do so in a timely way, especially when lives are at risk. We are experts in this area. Last year alone, the Thunder Bay Police Service investigated 184 cyber-related cases. This involved more than 140 production orders and 80 search warrants, and over 1,370 devices being seized for examination. These efforts led to 20 victims being identified and more than 240 charges laid. This is impressive for a 5-person unit. But this is not about statistics. It's about protecting people. The Bill C-22 will help services like ours facing increasing demands with limited resources reach victims more quickly. Let me illustrate this in a more realistic scenario. Imagine a missing 14-year-old girl, Shauna. Her parents report that she has been communicating online with someone they believe is exploiting her. Investigators identify a username linked to a messaging platform. Time is critical. Under the current framework, confirming which service provider holds that account information and obtaining the basic subscriber data needed to proceed can take valuable hours or even days due to fragmented processes and outdated legal pathways. Meanwhile, evidence suggests the suspect may be attempting to move Shauna across provincial or international borders. Every hour matters. Under Bill C-22, investigators can more quickly confirm the service provider tied to the account and proceed with the appropriate judicial authorization to obtain further evidence. In urgent circumstances, they could request limited emergency access to data to prevent imminent harm while remaining fully accountable to strict legal thresholds and oversight. That time saved could mean locating Shauna before she is moved, before further harm occurs, and before critical evidence disappears. This is the reality police services face every day. We have multiple examples in Thunder Bay where we have youth as young as 14 coming from being exploited and coming to our community from Southern Ontario. The Canadian Association of Chiefs of Police has endorsed Bill C-22 because it strikes the right balance. It streamlines access to essential information, improves emergency data sharing, and clarifies voluntary disclosures while maintaining strong judicial and privacy safeguards. The Ontario Association of Chiefs of Police has also consistently called for modernizing lawful access tools. Our members see firsthand how individuals and organized crime group networks have exploited legislative gaps. These actors are sophisticated and constantly evolving. To keep communities safe, policing must evolve as well. Lawful access tools are not about surveillance or reach, they are about public protection. They allow investigators to understand criminal networks, prevent violence, and rescue victims. Whether it's locating a missing youth, disrupting fentanyl trafficking, dismantling human trafficking networks, or combating online exploitation, clear legal frameworks and modern tools are essential. Bill C-22 represents an important step forward. It acknowledges that modern crime requires modern solutions. It ensures police can act quickly in urgent situations while remaining firmly grounded in judicial authorizations, privacy law, and the Charter of Rights and Freedoms. At its core, the legislation is about protecting Canadians, especially the most vulnerable among us. I urge and support you to support the timely passage of Bill C-22. Thank you.
Thank you, Chief Fleury. Now we will go to Chief Demkiw for 5 minutes, please.
Thank you, members of the Standing Committee on Public Safety and National Security. Thank you for the invitation today to join you. The Toronto Police Service, along with the broader policing community in Canada, has long advocated for reforms that put public safety first, including reforms related to lawful access. We believe that Bill C-22, an act respecting lawful access, is a step in the right direction. It will provide additional tools for our officers to be able to move investigations forward more quickly, hold offenders accountable, and prevent harm. Preventing harm often requires the ability to intervene early, including in cases involving violent extremism. The Toronto Police Service is the biggest municipal police service in Canada. Policing in Toronto is extremely complex. In addition to all the unique aspects of the city, we often see trends here before they begin to appear in other areas. We see the ripple effects of geopolitics and a rise in hate crimes. We see frontline situations rooted in the complexity of mental health, addiction, and unmet social needs. Toronto is home to the majority of councillor offices in Ontario. The city is host to many major international events. We are seeing more young people becoming involved in violence, often communicating anonymously about potential targets through digital platforms. Addressing these issues requires support and collaboration across the broader justice system, including through legislative reform. In many ways, new technology and communication enhancements have made our lives easier, but they have also made it easier for criminals to plan their activities and avoid justice. We are seeing bad actors use digital tools for all kinds of crime, including drug trafficking, extortion, child pornography, hate crime, extremism, and other serious offenses. Our role is to prevent these offenses, to bring offenders to justice, and to provide a voice for victims who have experienced some of the most difficult circumstances. However, because technology has evolved so quickly in recent years, we are encountering roadblocks in some of these investigations. Take, for example, the issue of confirming which telecommunication service provider has information that will assist in an investigation. Presently, this process is time-consuming and potentially leads to loss of evidence. Bill C-22 will streamline our processes and allow police to advance investigations in a timely manner. As the criminal world evolves, law enforcement and the justice system must keep pace. It is important to note that some of these tools are already available in other Five Eyes countries. The Toronto Police Service strongly believes that lawful access will reduce delays in accessing critical information and, in doing so, enhance public safety. Thank you, and we look forward to continuing our work with all levels of government to ensure the justice system upholds accountability and protects our communities.
Thank you, Chief Demkiw. With that, we will get to our first round of questions, and I will exercise my prerogative as chair to take 6 minutes for questions. This is something I've spoken with the Honourable Parliamentary Secretary and my colleague from the block about. Thank you all for being here, and this is an area in which you all have a lot of expertise. Thank the two police chiefs for their service. Professor West, it'll probably be no surprise. I'm going to start with you with our questions. We spoke sorry, I'll just restart the timer there. If we could just restart the timer for mine, please. Professor West, I wanted to ask you about encryption. Is it sufficiently defined? Is it not sufficiently defined? What, in your legal opinion, where, in your opinion, would you land given what we see in the bill on the definition of encryption?
So as far as I read the bill, there is no means by which the government could say you have to force open your encryption if you don't already have the capabilities. And I say that because both for the regulations and for the ministerial orders, it says that you cannot require or you cannot comply with an order or regulation if it requires instituting a systemic vulnerability into your system. And the way that systemic vulnerability is currently defined includes encryption because of the definition of electronic protections. So my concern is more over the fact that there could be other forms of systemic vulnerabilities built into the hardware or operating system that don't get captured by the definition of systemic vulnerability, and that's where I see a gap.
Okay, so I'm going to have you expand on that, please. When you talk about these vulnerabilities, I assume these might be vulnerabilities that the provider might not even know about. Is that accurate?
Correct, but because we don't know who a core provider would be and who could be captured by this act, there could be hardware providers, for example, who could be service providers who would be captured, and the definition of systemic vulnerability as it stands wouldn't capture their activities. And I know you're going to hear from Professor Diab later, and he also has thought about this as well, so I'd turn to him more on that.
Right, because in the legislation, the bill Part 2 would apply to those who are defined as core providers or who meet the definition of core providers, or, if I recall correctly, those who are designated by ministerial order. Is that
That's my understanding, yes.
So theoretically, somebody could be designated by, or a business could be designated by ministerial order, and they would then be subject to this. So it's essentially, if I get what you're saying properly, that's kind of boundless or limitless in terms of we don't know exactly who this is going to be applied to. Do I have that right?
Well, my understanding is that they would still have to be an electronic service provider, but the definition of electronic service provider is fairly broad, so it could capture people who provide hardware services, for example.
So I'm going to ask you, this is an interesting question that was brought to my attention. Let's say a business provider has a capability, Alexa, for instance. I think that's the Amazon. That's Amazon, I believe. Is that right? Something like that. Alexa theoretically could listen to your conversations, or every time you say, "Hey Siri," Siri starts to listen, right? So could it be possible that if Apple has the ability, and sorry to pick on Apple, but if anybody has the ability, any company has the ability, that they could say, okay, every time you say, "Hey Siri," that has to start listening. That app has to start listening, and the app itself or the provider itself has the ability to listen, right? So it's actually not necessarily it's not asking the provider to create a new power. It's almost asking for it to go one step further. Are you with me so far?
Yes.
And as I understand it, if such an order was made, that order would not possibly be secret. That would be secret. In which case, a whistleblower couldn't necessarily come forward. I guess the only recourse there would be for the company who is doing that to apply for judicial review. Is that accurate?
So if there was a ministerial order to have that capability, that ministerial order would have to be reviewed by the IC and approved. And then, yes, with consultation, there's consultation built in to require that consultation with Apple in this case. But if that approval was still done, then there would be JR. But then on top, you have to layer on top of the fact that nobody could access that lawfully without a warrant for interception. So just because the service provider wouldn't have the capacity doesn't necessarily mean that the law enforcement would then all of a sudden have access. And if in that case, you wouldn't really be instituting a new vulnerability because they already had the capacity. So really, you're just giving law enforcement the capacity to tap into something that already exists if they had lawful authority.
Right, and I suppose in this case, I guess the difference might be that the police could say, we believe Professor West has committed a criminal offense and that her use of Siri holds evidence of that. We are going to get a warrant that does this. They could get that now. The only difference is that under Part 2, there would be a requirement to bring up the capacity to do that or the capability to do that, whereas right now it would just simply exist, if that makes sense.
That's my understanding.
Okay, thank you. My 6 minutes are up. Monsieur Ramsey, vous avez 6 minutes.
OK. Donc, ma question s'adresse.
My question is for our two police chiefs. One of the things we have to keep in mind and keep in perspective is that Bill C-22 would give law enforcement authorities to act in a timely manner. And Chief Demkiw, I think you mentioned that it was otherwise time-consuming. There was a potential loss of evidence. But what I'd like to hear from you is in the case of internet fraud or cyber criminality, extortion, or vehicle theft, am I correct in thinking that acting quickly, instead of talking about dozens or a few cases, if an investigation lasts 12 to 18 months, could this involve hundreds of victims? And in the case of cyber criminality, sextortion, we're talking about a lot of victims here. So I'd like to clarify that with you. There is a big difference between having one victim versus 200, or one case of cyber criminality versus 12. And this is where C-22 is supposed to make a difference.
My question, and the short answer is yes, time is of essence. And whenever time is of essence in cyber criminality, fraud, or extortion, you certainly risk greater victimization, both by the number of victims and by the impact on individual victims. As we know, sometimes people are victimized many times over. And to your point, as our investigations are sometimes hampered and take longer to unravel the digital evidence that needs to be uncovered to stop the victimization and criminality, more victims happen during that time.
Chief Fleury, would you like to add to this?
Yes. So just maybe in the example you used on fraud, for example, fraud-related offenses, let's think of an example of a Ponzi scheme. In a Ponzi scheme situation, if we have one victim or two victims or three victims that we've identified, and we're able to get into that material and get into that information early on, there's a really strong possibility that the quick access to that information will stop further victimization or other people becoming victims before we have an opportunity to finish up the investigation. And I have seen that happen in the past where time is of the essence when you're talking about these people are very motivated into doing their crime and they will multiple victims very quickly. If we have the ability to get in there, might be able to interrupt some of the activity while we're forming grounds to lay charges and proceed with the court proceedings. So I think it's really important to have that early access on those types of scenarios.
Thank you. L'autre point, c'est que des fois...
The other point is this. Sometimes we have the impression that some people think C-22 goes too far. However, with C-22, the government really showed a lot of discipline and focused on what was essential. At a certain point, there was talk of requesting information on vehicles, taxis, and even from hotels, but the government decided to not include the coverage of those things. Do you believe C-22 is well calibrated and is only looking for the obtention of essential information?
If I may start, the short answer is yes, I believe it is. It's, we know from practical experience, the use of digital technology by the criminal element has expanded dramatically, and our ability to gather timely evidence and preserve evidence and prevent the escalation of offenses is hampered by the inability to access key digital bits of evidence, and C-22 will assist us in that regard. I think just by way of a simple example, having a phone number tied to a particular set of criminality, no matter how serious the alleged crime, we have to establish who the service provider is. And that in and of itself is a cumbersome task today, where C-22 will streamline that and allow us to move more quickly, gather essential evidence that may be disappearing and lost while we wait for different service providers to advance our investigations through the current legislative framework. So C-22 is calibrated well to assist us in making access to key digital technology in a timely way more readily possible.
Yeah, and I would agree with Chief Demkiw. I think it's very, very well put together, and it does address those areas that are, data moves so quickly that I think it does a good job at collecting that.
Mrs. West, I believe when it comes to electronic protection safeguard, I believe Canada with Australia are the only countries where there's explicit prohibition against electronic protection safeguard implementing a capability that would introduce a systemic vulnerability. For instance, in the USA...
Désolé, Monsieur Ramsey, your time is up. And no, I didn't look forward to saying that. Madame de Bellefeuille, vous avez 6 minutes.
Monsieur le Président.
Thank you, Mr. Chairman. Ms. West, Professor, in a joint letter, several organizations from civil society expressed concerns that Bill C-22 might make it easier to exchange information with foreign governments, including with states whose human rights practices raise concerns. What additional protections should be considered to limit another use of the information of Canadians?
I think there's two issues. The first is on the changes to the MLAT, which would allow foreign entities to serve orders on Canada, and then through the process of the minister approving the request, going through a judge, and then the judge agreeing that the criteria made out in the criminal code are met, and then collecting that data back. Now, there is no requirement that the law for which is under investigation be a crime also in Canada. So there is the possibility that you could see foreign governments seeking to enforce repressive laws or politically motivated investigations through this process. And there's no real safeguard for that. but for the actions of the minister and him executing his discretion. And so I think in this case, especially because there's not a judge necessarily involved in the foreign jurisdiction, it can be an administrative order, the minister has to commit to exercising his discretion to not authorize the process where there is potential that the crimes being investigated are repressive or politically motivated. There's no safeguard in the law. They could, by adding the fact that the law would similarly have to be a crime in Canada, and then we wouldn't have that problem. So that's one way to make it broader. But as of right now, it would be at the minister's discretion, I think.
Merci.
Thank you. This is something I worry about a lot. If you could suggest a specific amendment to the bill to reassure the people who raised those concerns with us, that would be very helpful. You would have until May 27th to table any amendments you think are necessary. Now, you wrote a letter to the Globe and Mail where you said the work of this committee was very important and finding a consensus around the bill is also very important. I think everyone around this table believes C-22 is necessary, but perhaps it could be improved. So do you believe it would be reasonable to add the National Security Surveillance Office and that it be informed in real time when a ministerial order is emitted to conduct an investigation to make sure there's no abuse?
No, I don't. I think the National Security Intelligence Review Body is a review body. It engages in ex post fact review. It doesn't have a current mandate where they're actually engaged in oversight right now. The body that we have, and I personally recommended that the Intelligence Commissioner should be involved in reviewing ministerial orders because they have that role of oversight in the current system and they're set up to do that in a way that NSIRA is not.
Parfait. Alors, l'idée étant que...
The idea being not that the agency be involved in the decision, give its opinion, whether yes or no the ministerial order should go ahead. But perhaps it could be notified in real time to keep a record so that if ever there is an investigation, you could go back and look at that record. Can you be a little more specific? Because I might have misunderstood because of the interpretation.
So I certainly see a role for NSIRA in reviewing the system in general, and potentially a role for your colleagues on NSI COP here down the road. And I think that will be exceptionally important, in particular, looking at how the role of engagement with the service provider community is rolled out. Whether or not NSIRA needs to be informed every time there's a ministerial order in order to do that, again, I think they're more set up for longer-term oversight, or longer-term review, and they would be best, receiving information at the end of a calendar year or every 6 months. I don't really think they're in a position to do case-by-case review.
Parfait. Pourriez-vous, vous avez parlé que la définition de fournisseur
You spoke about the definition of electronic services provider. It's a very broad definition. It could include equipment manufacturers or providers. Can you give us some concrete examples of these equipment providers?
Sure. Really anybody who provides electronic services often provides, anyone who provides hardware often typically also provides some sort of electronic service. I think hardware providers like Ericsson and others who operate in the hardware space could find themselves captured by the broad definition. I don't think that's necessarily wrong. I think that the definition...
I'm sorry, Professor, we'll have to pick that up in the next round, and we will move on to Ms. Kirkland for 5 minutes, please.
Thank you. My questions will be for Ms. West, and I appreciate your testimony here.
Given this is our 9th time, as you said, you believe, trying to get this legislation right in terms of lawful access, how important is it that you said strike a right balance, right? How important is it that we're not racing to royal assent and that we are taking the time to review amendments and listen to testimony?
In my opinion, it's crucial to getting the bill right.
Thank you. We know that you have said publicly that the government should show its homework, and I appreciated that, especially to folks on this committee who are part of making this legislation go through this process. We know that in consultation with Murray Rankin, he produced a report which informed Bill C-22, and the Minister of Public Safety told the committee that the report was used specifically to inform the government's decision-making on C-22, and I know you participated directly in that consultation. In your professional opinion, is there any legitimate national security, solicitor-client privilege, or operational reason preventing the report from being released to Parliament or the Canadian public?
I'm not privy to the relationship that Murray Rankin had with the minister when he offered his advice, so no.
Okay. From your perspective as a participant in the process, how central was the consultation exercise to shaping the lawful access now before Parliament?
In my opinion, it reflects the type of advice I was hearing as part of the consultation process.
Okay, great. To your knowledge, were participants in the consultation process ever advised that the report or its findings would remain confidential from Parliament?
That wasn't something discussed.
You never discussed that? Okay, thank you. So without actually, just one more question. In your experience, is it typical? I mean, you've probably been part of these processes before. I assume you have been. I could be wrong. Is it typical for consultation reports involving external experts and stakeholders to be withheld entirely? Have you seen that before?
I've never been involved in a consultation that was run by an external party before, so I'm not sure. Typically, I've been involved in consultations that are run by the government themselves.
If I could just interrupt for
usually...
just one moment, please. We have a meeting here. I don't mind whispers. I know that's going to happen, but I would just, if it doesn't need a meeting, we should go outside, please. Thank you.
That's all right. I've never been involved in a process similar to this. In the past, in government consultations, I've seen, what we heard reports been published, but this was a different kind of process.
Okay, I think it sounds like in part of the process, you may have seen the report. Can you comment on whether it would be helpful for us?
I didn't see the report.
Oh, okay.
I saw a list of recommendations.
Okay, so you saw the list of recommendations. Without disclosing anything confidential that you may have seen, can you tell the committee whether the report reflected a diversity of views? Do you know if there were recommendations including concerns and cautions raised by experts and stakeholders in terms of privacy?
Yes, because my own concerns were reflected in the list of recommendations.
Okay, thank you. Beyond that report, I would just like you to expand a little bit more on the specific recommendations you have for amendments. If you could just take one or two that you think would really make this bill a much better bill. We're not arguing that lawful access isn't. I mean, we know lawful access and how important it is, and I appreciate the chiefs on the call or on the meeting as well today because of how important it is. Can you just give us one or two amendments that could seem fairly simple and that you think we could all agree on in order to get this right versus racing?
Yes. As I mentioned, I think I would implore the committee to hear from technical experts who know better than a lawyer how to capture all of the type of vulnerabilities that you would like to avoid in the definition of systemic vulnerability. I also think the currently, as drafted, the retention provision is overbroad. We've seen similar provisions, actually even more narrowly tailored ones in Europe, be found to engage the right to privacy and be unreasonable. I think that amendment or that provision in and of itself needs to be reformed to ensure that any regulation is narrowly targeted, necessary and proportionate, and that reflects the seriousness of what they're asking for, which is the creation of large pools of private data.
Okay, thank you. Because we know that broad definitions often lead to future governments misusing or abusing legislation.
Fortunately, Ms. Kirkland, your time is up. And up next is Madame McCann pour 5 minutes.
Thank you very much, Mr. Chair. And Dr. Leah, it's great to see you again. So my question to you will be on the foreign entity request. Canada is currently the only Five Eyes and G7 member without modernized lawful access legislation. And does our lack of a technical capability framework hinder our ability to cooperate with the international partners on transnational threats? And how does Part 1's new mechanism for foreign entity requests solve this problem?
Yes, it does. My understanding, looking at and talking to folks across the Five Eyes, is that in other jurisdictions, the threshold upon which they can obtain subscriber information is lower than that in Canada. So often it's not required to be judicially authorized, or it might be on a reasonable suspicion standard, or even lower than that. And so when they try to serve Canada, or try to use the MLAT process in Canada, there's no parallel in Canada that would allow us to enforce their orders. So by having a new provision that's focused specifically on subscriber information and transmission data with a threshold of reasonable grounds to suspect, it would allow us to partner better with foreign jurisdictions, because it would be more in line with how they obtain subscriber information in their jurisdictions and allow for kind of equitable enforcement.
Thank you very much. So I'll focus on primarily on the operational side of policing and ways to support the work that the investigators do when it comes to combating organized crime, extremism, and child sexual exploitation and other complex crimes. Chiefs, Bill C-22 creates a confirmation of service demand, which simplifies the process by which law enforcement identify the proper recipient of a production order. Would you say this helps in the context of a time-sensitive investigation dealing with organized crime, extremism, hate, or child exploitation? And how does it provide main operational benefits to you? We can.
Thank you for that. I think the practical reality is we often have a phone number or other clue that requires us to then pursue the digital footprint, the digital evidence that that phone number or other information provides. And in the present regime, there is no provision for us to make a demand for service providers. We have to do production orders multiple times to simply identify that this is a service provided by a particular telco, for example, and there's an incredible amount of time spent doing that. Just by way of example, numbers-wise, over a 20-month period, our detective operations alone in Toronto did 1,900 production orders. And something that would help us very much is to have the ability to understand which service provider to focus our investigative efforts on, and then pursue that through a judicially reviewed process of production orders or warrants. And that saving of time is very real and very much will impact our ability to succeed. The type of evidence that can get lost while we determine who the service provider may be, video evidence, forensic evidence, and as was asked in the previous question, may involve greater victimization or ongoing victimization that proceeds for a longer period of time while we in the present regime determine who the service providers are. So the ability to know where to focus our investigative energy quickly and then go through the process of gathering evidence through production orders, which is scrutinized by justice, is something we very much welcome.
Thank you very much. So in this context, Bill C-22 has metadata retention requirements where core providers are keeping this, metadata is to be held for up to 12 months. And yesterday we heard from officials that in Australia, they keep it for 2 years. In UK, they keep it for 1 year. Would you say that requiring core providers to retain metadata for 12 months is a reasonable time frame, given the fact that how quickly providers may otherwise delete the data? Sometimes it's 30 days, sometimes it's 3 months. while still remaining flexible for providers and supportive of investigators, especially when some complex cases can go beyond 3-6 months or even like over a year?
Well, maybe I'll start with this one, and maybe the chief can follow up. But yeah, I think 12 months is a good start. But obviously, yes, you're right. If the investigations are prolonged, and they can be very long in some of these cases, then retention beyond the 12 months, 24 months, 36 months would be ideal. And I think maybe that's something.
Sorry, Chief Fleury, but we have to cut you off there. I apologize.
No problem.
Next up, Madame de Belfay pour 2 minutes et demie.
For 2.5 minutes. Thank you, Mr. Chair. Professor West, you heard the 2 police chiefs talk about how long data should be kept. You said a year is too long. But in light of what the police chiefs just said, a year is the minimum. 2 or 3 would be better. How do you see that? Do you feel data should be held for less of a long time? Do you agree or not with with the other witnesses?
I certainly understand from a law enforcement perspective why they would want all of the data that they need to be available for as long as necessary. But in terms of charter protections, my opinion is informed by what I've read of European jurisprudence on this issue. And it's not just that it's 1 year, it's 1 year for any type of data for any purpose. So mischief, investigating, jaywalking, for example. I'm not saying that that's what they would do, but it's the fact that it's for any purpose, for any type of data, right, that creates a chill in people that they could be under surveillance, that all of their data is being held for this long period of time. Right now, there's nothing that constrains the retention. Right now, it's any type of data for a year for any purpose. And I think that's what needs to be amended to make sure that it's more narrowly tailored to the type of data and the requirement in the investigative imperative.
If we want to share information with the Five Eyes, don't we need to hold on to data information, the metadata, as long as Five Eyes members?
In the Five Eyes, it's varied. For example, in the United Kingdom, they can only, in Europe and in the United Kingdom, it's only for serious crime. So it's not for everything that they can go and retain information for a year. In the United States, their authorities don't allow for year-long retention. That's not part of their act. And so every...
Désolé, malheureusement.
I'm sorry, Madame de Bellefeuille. Unfortunately, your time is up.
Mr. Lloyd, you have 5 minutes.
Thank you to the witnesses for being here. Dr. West, one concern that I've heard is that many tech companies advertise that they have privacy controls. For example, companies that have smart devices in homes advertise that the microphones can't be turned on remotely so that they can listen. Under this legislation, it's kind of odd to me that it talks about how it's content, it's not here to look at content, but that the ministerial orders can order these companies to provide the capabilities to turn on a remote microphone. Is that correct?
So where they talk about content, that's in terms of retention of data. But it does allow for the creation or the ordering of intercept capability. So that would be an intercept capability. And now you could potentially have an order that would require that capability. And as long as it didn't create a systemic vulnerability, yes, it could be implemented. And they would have to change their advertising.
Now, that kind of creates a bit of a conundrum, because what if it's a secret ministerial order?
So, true. I don't have an answer for you.
So for the benefit of the committee and those watching, if a company says that, remote microphones can't be turned on, and the government issues a ministerial order saying you need to build in the capability to turn on a remote microphone, the company in question could not change its advertising to say we will not remotely turn on your microphone without violating the very non-disclosure and secrecy clause. So they will still be advertising that they will not turn on remote microphones while the government has forced them to create that capability for law enforcement.
I'm not sure how a company would manage that situation.
It's just kind of an issue for me, I think. On another aspect, I'm concerned about blanket, you've talked about this blanket metadata. I can certainly understand wanting, like if you suspect that somebody or a group is involved in a criminal activity, that you could order, and I think that already exists, preservation orders already exist. But if we're talking about a blanket requirement that the metadata of all Canadians, and all people residing in Canada, be kept for up to a year, that creates a lot of very interesting constitutional, privacy laws. Do you have any thoughts on that?
I agree. I listened to the previous the questioning in the last testimony about whether or not this creates a seizure, and if it doesn't create a seizure, would it still violate Section 8? And I think the fact that there would be a serious chilling effect and a belief that people lacked privacy, because ultimately the state could then access through a subscriber production order, not a subscriber production order, but a transmission production order, a tracking production order, even location data for any crime going back up to a year, right, does create a chilling impact and would have serious implications for how people view their right to privacy in Canada. Yeah. And it wouldn't just be people in Canada, or it would be anyone who has services with a Canadian company.
And I mean, I'm less concerned about the people committing crimes. I'm concerned about the innocent Canadians whose metadata is going to be collected. Are you at all concerned? We saw with the Salt Typhoon hack in the United States, where some very sensitive personal data was hacked by foreign agents, and it was discovered after the fact that it was the systemic vulnerabilities that were required by the U.S. government that allowed for this. If we create, I know the legislation says that it doesn't want to create systemic vulnerabilities, but I'm not sure that lawful access can be facilitated without creating. You said there's a risk. And then we're also talking about forcing companies to keep people's metadata blanket a whole country for an entire year. Are we not creating a treasure trove of people's personal data that hackers are going to want to have access to?
As I said in my opening statement, any point of access that is created that doesn't exist, and any pool of data that you're creating that doesn't previously exist, creates new risks. And so the regulatory framework.
Sorry to have to cut you off, Professor West. Avec les dernières questions.
Mr. West, final questions.
Final questions, Dr. Pawlowski.
Alors, j'ai besoin de poser une question.
Well, I need to ask a question in French.
Good to see you out there, even though you're on a screen. So I've gotten to know Darcy pretty well over the last few years, and I got to say he's a wonderful chief in Thunder Bay. I'm really glad you're here. You gave one concrete example of a 14-year-old girl. I don't know, maybe you can tell me after I finish posing this rather lengthy question, whether that was a real case. But I wondered about other cases that you've encountered, the public, or if you just want to disguise sufficiently who you're talking about, but other cases where lawful access would be helpful to you. I would certainly think in terms of child pornography, but I think especially in a place like Thunder Bay, there seems to be a real issue with trafficking people. There's also, as we both know, a big issue with gangs from Toronto, gangs from Ottawa coming up to Canada, or to Canada to, I guess you're Canada down here in Toronto and Ottawa as well, but coming up to Thunder Bay. and committing crimes in Thunder Bay. There must be communications between the gangs back and forth between Toronto, for example, and Thunder Bay. Can you give other examples how lawful access would help you in doing your job and addressing these problems?
Yeah, thank you. So that case, so the real case, for example, is those youth that are coming up to us from down south. And we see them on a regular basis, some as young as 14 years old. And of course, we do have concerned parents that are reaching out and asking for some support, originally from Toronto Police and on to us, asking for some support to locate these kids. So really, when we're talking about the exploitation of these youth, they're getting involved in all kinds of different crime, gang activity. And I think that kind of the legislation, the easier, not the easier, but the more immediate access would be a real benefit to us when we're starting to see the chains, the links between some of the groups down south and these kids that are coming up here. It would be really beneficial to us to get ahead of it, especially when we're looking for these youth. I mean, we do have real life cases where we've had families come up and they've been asking us to go out and help search for the youth, and quite often we do find them involved in the drug activity or the gang related work that's being done in this community. So that happens on a regular basis. I'd say. On average, right now, we probably went from 60% to 50% of our people involved in that type of activity do come from Southern Ontario, and that again is very young people that are being involved and are exploited. We are looking at some of those cases. Are they human trafficking, or they are being human trafficked? They come in, they get into our fob houses, and then they end up doing all kinds of activities. So this is a real concern for us, and I think if we had the ability to access a little bit sooner, it would be a definite benefit to us to enforce some of the acts that we do.
Now, Chief, I could see in that situation where there are young people, 15, 16, involved in crimes coming up, and how you might want to be able to access their data, for example, on their cell phones, their internet, emails. But that's desirable, but there's a concern about the slippery slope. And although that may be desirable, how do I know that this doesn't involve, like, basically looking in on, I've got a 17-year-old boy. I mean, he's in a social circle. They have girlfriends. They're always socializing back and forth. How do I know that basically everything they do, including talking to Siri, doesn't go to the police? Which would seem to be an unnecessary violation of things that we think ought to be confidential.
Right, and I think police services across the country are very, very good at identifying the specifics of what they're looking for. So going back to my presentation, this is not about an overarching, wide open playing field for the police to go in and get what information they want. It has to be specific to the event that we're looking for. For example, if we have a missing youth from Southern Ontario, we would investigate that as a missing youth, and if we had access to their data and the material that they had, may show those connections immediately that would allow us to start formulating a bigger investigation and the contacts and their associates that they have that may be in Thunder Bay or may be down in the Southern Ontario, which would really help us further our investigation a lot quicker and perhaps solve some of the victimization or even some of the illegal activity that they're doing. It would be very focused. It would not be wide open.
Ms. West, if I could ask you, and it did kind of, I hadn't thought about something like Siri, but that's internet data. If I jokingly, in response to my 16-year-old kid, he asked me something and he said, well, if you do, I'll beat you with a baseball bat. Jokingly, say that, and I mean, Siri picks that up.
Unfortunately, Dr. Pawlowski, that is the last thought of this round. I'd like to thank all of our witnesses for being here. We will suspend for the next witnesses to come on board. So thank you all for being here again for the second hour. We have 2 witnesses in person and 1 witness by video conference. And I understand that Mr. Fraser, who is by video, has been sound checked. Thank you for appearing. We also have Dr. Robert Diab from Thompson Rivers University, woohoo, and Dr. Michael Geist from the University of Ottawa. I'll just leave it at that. Professor Diab, could you please go forward with your 5-minute opening statement?
Thank you, Mr. Chair and members of the committee for the invitation to appear today. I'm a professor in the Faculty of Law at Thompson Rivers University, and my area of specialty is Section 8 of the Charter, which protects against unreasonable search and seizure. I want to begin by acknowledging that Bill C-22 marks a meaningful improvement over its predecessor, Bill C-2. Several of the powers in the bill have been more appropriately tailored.
Just one moment, please, Professor Diab. I understand we're having some difficulties with...
I just wanted you to speak up because I'm having trouble hearing you.
Okay, thank you. Yes, thank you.
Thank you, Mr. Chair.
Thank you.
Several of the powers in the bill have been more appropriately tailored to the needs of law enforcement and to the privacy interests at stake. But I would like to highlight and briefly walk the committee through what I believe are 3 significant weaknesses with the bill that remain. The first is the new production order for subscriber information to be added to the criminal code. The government's charter statement defends this power on the basis that subscriber info is not particularly sensitive, since it only reveals the name and address of a person that is obtaining a service from an entity like Rogers. But the power as drafted would disclose much more than this. Police can obtain not only a name and address tied to an account, but also the types of services a person subscribes to, the tiers or channels associated with those services, and the identifiers of every device associated with the account. It also applies to any person who provides a service, so not just companies like Rogers. All of this certainly allows for capturing sensitive information. For example, what cable packages a person subscribes to, or what medical services they receive. A power to obtain this shouldn't rest on reasonable suspicion alone. The scope of the power should be narrowed. As it stands, I think it would likely be struck down under Section 8. A second concern I would like to raise is the definition of systematic vulnerability. I understand that Professor West has dealt with this earlier, but I'll just try and target my remarks here. So there is a definition that's good, but it remains too narrow in 2 ways. The test for what constitutes a vulnerability here is defined to be one that creates a substantial risk that secure information could be accessed by a person without authorization. That's too high a threshold. Recent developments with AI in recent weeks reveal its far greater power for hacking. So even a remote or theoretical vulnerability now could be readily exploited. The definition also applies only to vulnerabilities in the electronic protections of an electronic service. So it may not extend the definition to operating systems of devices. So a ministerial order could in principle require Apple or Google to build extraction capabilities into an operating system without engaging the safeguard, even if the practical effect would be to undermine end-to-end encryption. The third concern with the bill, in my view the most serious, is the metadata preservation power that the committee spent time on a few minutes ago. This would authorize core providers, would require core providers to retain transmission data for every communication for up to a year. So that's where and when we used our phones, coordinates of who we were in touch with when and where. The charter statement doesn't address this at all. Its position appears to be that compelling a provider to preserve metadata is not itself an interference with privacy, because police still need a warrant or other authority to access the data. It is not a seizure, they imply. It does not engage Section 8. But this is not so. We know from ample case law that metadata is private, and under these provisions, when the minister compels Shaw or TELUS to preserve our metadata, the company is doing so on behalf of the state and for a law enforcement purpose. Those are the basic elements of a seizure under Section 8. It's worth noting that Parliament assumed precisely this 12 years ago when it added to the Criminal Code the power to make a preservation demand or order, which requires individualized suspicion, reasonable suspicion, a warrant, depending on the case. And this is key. It makes it a criminal offense to hold data, if you're Shaw or TELUS, et cetera, beyond whatever the period at issue is. Why would Parliament have assumed authority was needed to preserve data if it didn't engage Section 8? So nothing here changes, in my view, in light of the fact that police are saying, no, but we won't look at it unless we go get a warrant. That's also true right now, that in order to see the things that they demand, to be preserved, they need a warrant, but even preserving it is...
Thank you, Professor Diab. Parliament, we're used to the going down, so I apologize to cut you off. And I'd like to welcome MPs Kayabega and Baber to the table as well. Professor Geist, Dr. Geist, please go ahead with your 5-minute opening statement. Thank you.
Sure, thanks. Good afternoon, everyone. And thank you for the invitation. My name, as you heard, is Michael Geist. I'm a law professor at the University of Ottawa, where I hold the Canada Research Chair in Internet and E-commerce Law. I appear in a personal capacity representing only my own views. In preparation for today's hearing, I looked back at the history of my engagement with lawful access policy. I found that I wrote my first op-ed on the issue more than 20 years ago and first began appearing before committees on various bills a few years after that. As I'm sure you know, lawful access has been the subject of legislative debate in Canada for decades, under both Liberal and Conservative governments. The technologies change, the governments may change, but the challenge has always been the same: to give law enforcement and security agencies the tools they need to address serious crime while respecting Canadians' privacy rights and the constitutional framework the Supreme Court has built around privacy in decisions such as Spencer and Bykowitz. Bill C-2 is what happens when the bill is not well struck. The balance is not well struck, as its warrantless information demand power envisioned compelling disclosure of subscriber information of any provider of a service in Canada without court oversight. The decision to drop that power was the right one, and replacing it with a confirmation of service demand is a meaningful change. Bill C-22 nevertheless contains some serious problems, and I'll focus on 3. They're going to echo what we just heard from Professor Diab. The first I'm going to focus on is the mandatory metadata retention regime, which would require providers to retain metadata for up to a year on every subscriber, regardless of suspicion. On a mobile network, that data includes cell phones, cell towers. Each phone connects to and when retained at scale, the aggregate amounts to a comprehensive surveillance map of virtually every Canadian, where and when they go and who they interact with. This is the kind of bulk data retention regime that the European Union Court of Justice struck down in the Digital Rights Ireland case, and in the Teleseverage case extended to mandated private sector retention of traffic and location data. Germany's Federal Constitutional Court has reached similar conclusions, yet the Charter Statement on Bill C-22 remarkably fails to address the regime despite the obvious Charter implications. The committee is being asked to entrench a surveillance architecture and accept the security risks that come with it. The obvious approach is to remove this entirely, as it is disproportionate and, I believe, likely to be struck down in its current form by the Supreme Court. Alternatively, perhaps a 30-day cap on metadata retention would suffice in terms of meeting the immediate investigative needs while allowing for a court order if a longer period is required. The second concern involves systemic vulnerability safeguards in the technical capability provisions. Sections 5 and 7 of the SAAIA, that's Part 2, say providers are not required to comply with an order if doing so would create a systemic vulnerability. But Sections 12 and 13 make compliance unconditional and provide that orders prevail over inconsistent regulations. That leaves a safeguard that exists in name only, largely cloaked in secrecy, with the burden of invoking it falling on the providers. The consequence is a backdoor capability mandate that could weaken encryption, place user data at risk, and lead companies to remove privacy-enhancing services from Canada. This needs a fix that should include amending Section 12 to make compliance subject to the provisions of Sections 5 and 7. Further, the definition of systemic vulnerability should be expanded by the statute, clarifying that there will be no requirement to weaken or break encryption or introduce any security weakness. The third concern is the production order threshold for subscriber information. Bill C-22 sets the standard at reasonable grounds to suspect rather than the current reasonable grounds to believe. The Spencer and Bykovitz decisions establish a high informational privacy interest in subscriber data. Yet the Charter Statement nevertheless asserts that subscriber information sought does not by itself constitute particularly sensitive information. I think that sentence is difficult to reconcile both with Supreme Court jurisprudence and the technical reality of what subscriber information may reveal. Setting the bar lower invites further Charter litigation, placing the provision on shaky legal ground. Now, none of the changes that I've discussed here would be incompatible with effective law enforcement tools. Rather, they're about ensuring a framework that can withstand Charter scrutiny, respect Canadians' privacy rights, avoid creating a surveillance infrastructure, and sustain public interest and confidence. I look forward to your questions.
Thank you, Dr. Geist. And now we move to Mr. Fraser for 5 minutes, please. Thank you.
Thank you very much, Mr. Chairman, honorable members. Thank you very much for the kind invitation to share my views here on Bill C-22. I'm a partner with the law firm McGinnis Cooper in Halifax, where, among other things, I advise clients who are on the receiving end of orders for customer information. And I also teach at Dalhousie Law School. I'm appearing in my personal capacity, my own views, and I'm not speaking on behalf of any of my clients. I have to commend the government for its comprehensive consultation with stakeholders since Bill C-2, to which I contributed. But I still have a number of concerns and recommendations. And I'll note that in particular, Part 2 of Bill C-22 is very problematic. I can't cover all my concerns in 5 minutes, so I look forward to the rest of our discussion. First, I agree with my colleagues. We need to narrow the scope of subscriber information production orders or raise the bar up to reasonable belief. The bill lowers the threshold for police to obtain a production order for subscriber information, which they can get today, from reasonable grounds to believe to merely reasonable grounds to suspect. And the organizations that could be on the receiving end of these orders is anyone who provides services to the public, which includes a bank, a hospital, a grocery store, a hotel. So we're well beyond telcos here. Even though the definition is narrowed from the previous bills, police can still demand all the subscriber information that a service provider holds. And this goes beyond the name and address, as my colleagues have pointed out, and includes the types of services provided and device identifiers. That would include the serial number of your CPAP machine from your doctor's office, or compel Apple to hand over the digital IDs of every single device you have, including your AirTags and your iPads. That's too much. I would suggest narrow the scope of these orders or raise the bar to reasonable belief, or ultimately it will be found to have violated the Charter. But moving on to Part 2, the Supporting Authorized Access to Information Act. Nobody has really made a compelling case for anything in Part 2. The government has had 20 plus years to build their case, but as NCCOP observed, they only have anecdotes, and we should not be undermining the privacy and safety of every single Canadian based on anecdotes. Part 2 of the bill targets electronic service providers, but the definition is so broad, it likely includes most businesses in Canada. Everybody deals with digital information. If it proceeds, the bill should include necessary guardrails. Under no circumstances should the government be allowed to require an electronic service provider, particularly with a secret order, to make changes to products or services that a business provides in the ordinary course, collect and retain any data beyond what the business actually requires for its own purposes, or make any changes that would affect the functionality, including adding additional functionality for any products or services offered by the business. As written, the Minister of Public Safety could issue a secret order to turn your Amazon Alexa into a listening device, the example from the previous panel. And CSIS has explicitly said, in connection with this bill, they want to be able to track every single cell phone in Canada in real time, and that telcos are going to have to change their services to make every cell phone trackable. That is disproportionate and, in my view, actually absurd. Now, the government says we don't plan to undermine encryption and there are no backdoors, but you just have to read the words in the bill and you'll see that there's nothing to prevent that. Government officials said at this committee on Tuesday, I think it was, the bill is encryption neutral, but Canadians are not encryption neutral. The words of the bill clearly permit and certainly do not prohibit backdoors and mandatory decryption. And that's in secret with no transparency to Canadians and very little accountability. What the government intends is actually not relevant. What is relevant is what words end up in the statutes. Now, under Part 2, the Minister of Public Safety can issue these secret orders to service providers, to electronic service providers, very broadly defined, that come with mandatory permanent secrecy. Currently, the police and CSIS can apply to a judge for something called an assistance order, and that's to order a service provider to provide all reasonable assistance to give effect to a judicial warrant. This can be accompanied by a gag order if it's appropriate, and this is judicial control. Nobody from law enforcement has offered evidence that assistance orders are inadequate or should be replaced by these secret ministerial orders. The UK equivalent of a ministerial order was used by the UK government to secretly order Apple to remove encryption on iCloud globally. Part 2 of Bill C-22 does not contain any guardrails that would prevent that overreach in Canada. So secret ministerial orders have to go. Now, we also have the issue with metadata retention that my colleagues have already spoken about. This includes your location history. The government can require everyone's cell phone to become a retrospective tracking device going back a full year without any suspicion of wrongdoing. This will almost certainly be found to have violated the Charter. Collected metadata will be sought by Canadian and non-Canadian authorities based on mere suspicion. And that's a record of everyone who sought reproductive health care in Canada, which might be of interest to law enforcement from a Five Eyes partner. And finally, as legions of
Sorry, Mr.
cybersecurity
Fraser, we will have to stop there. I apologize.
Thank you.
As chair, I will be leading off this round for 6 minutes. I want to thank all of the witnesses, the quality of witnesses in our last hour, the quality of witnesses. We have a very academic panel this time. I'm very humbled by the three of you coming to spend your time with you today. And what do you know? We're all lawyers here. That's wonderful. So, Professor Diab, it's particularly great to have you here as a colleague at the bar with whom I dealt with in the bar in British Columbia in my time as a prosecutor, and also in my time teaching advanced criminal law and sentencing at Thompson Rivers University. I know everybody's very proud to have you here. So thank you for being here. With that, I want to expand a little bit on the question of engagement of Section 8. When it comes to the requirement of a third party to retain data. Is there a specific case you're relying on there, Professor?
No, I'm just relying on the broad propositions under Section 8. Section 8 is engaged whenever a state actor interferes with something over which we have a reasonable privacy interest. And so I gather the question you're asking is a mere demand by a state agent of a third party to hold on to the private data that belongs to the person over there. Is that an interference with their privacy? And I think it's... again, 12 years ago, Parliament assumed that if a court were to look at that, they would assume that it would be an interference with their privacy. And so in other words, I can't think of a body of case law where police told third parties to preserve data and then court, it was challenged in courts. I can't think of that. The story for me begins with the power, the preservation power. And when that was added to the code, it was added. I'm assuming on the premise that requiring a third party to do this for the state for a law enforcement purpose is an interference that engages Section 8. So once again, I mean, just if you stand back and ask yourself, how do you feel if you are told that TELUS, Rogers, etc., are preserving all of your movements, a record of all your movements, and the people to whom you sent emails, not the content, but those details. How do you feel? They're preserving it for up to a year for the purpose of potentially prosecuting you if necessary. And so maybe one answer is that's absolutely fine. But I think most Canadians, and I think courts are likely to say, no, they would think that the mere fact that I was visiting this person on this day or talked to this person, that's private. That should be private. There should be no record kept of it, and that is I think the best explanation I could give you as to why.
Thank you. I would like to ask the two professors in person on the reasonable grounds to suspect versus reasonable grounds to believe. It's been a while since I dealt with reasonable grounds to suspect, but my recollection of reasonable grounds to believe is that there has to be a subjective belief, as in you have to personally believe an offense has been committed, and that belief must be objectively reasonable. That's my recollection. In other words, a reasonable person would say, yeah, you had reasonable belief. Below balance of probabilities, so not ultra high, less than 50%, but above the suspect, which is more than a hunch, but less than that. What would you say to the proposition that, well, this is asking for very narrow data, so therefore we don't have to worry as much that this could be saved under Section 1. Would you agree with that, Professor Geist?
No, I wouldn't, and I wouldn't in two respects. First, the consistent claim that this data is of low privacy value, I think, is simply inaccurate. We just heard from Professor Diab examples. We could, and perhaps over the course of the next little bit, we'll have a chance to walk through some of those kinds of examples. But it seems to me, even the question that came up towards the very end of your last panel, which asked whether or not someone might know that you asked Siri something, the question isn't the content. The fact that you raised it and engaged with people, the fact that members of the public engage with you, and that a record would exist of who you communicate with, and there might be orders to have that kind of thing disclosed, raises, from my perspective, significant issues. This is creating, may have significant privacy import, and so lowering the standard for this information when there is scant evidence that the higher standard that we've had in place for many years now has posed a problem seems to me unwarranted.
I see. Now, to Mr. Fraser online, one of the things I mentioned last meeting when I wasn't the chair was that this is a highly technical bill, and we only had 1 hour with the officials. And one of the things you brought up to me that I wanted to address, or that you brought up to this committee, is you talked about CSIS wanting to have real-time access. That's something I think the committee may want to ask CSIS about. Can you just for our reference and just for our analysts, can you tell us where you got that point, please, in 25 seconds or less?
Absolutely. It was mentioned during the technical briefing when the bill was tabled. It was mentioned for Bill C2, and then it was mentioned again for Bill C22. And I have a copy of the slide deck that includes the illustration if you'd like it.
Well, I'm sure that we have that. I have 10 seconds left, but we are a little bit behind schedule, so we will now go to Mr. Housefather. Thank you.
Thank you, Mr. Chair. And wow, seating those 10 seconds will make a difference for sure as to when we end this meeting. Pleasure to welcome all the witnesses. And I think what we see with all of the different witness panels is that there's a general tension between... Oh.
We have a point of order here.
I believe that most people here don't wear an earpiece, but we have interpretation. It's very hard for me to follow. Everything's in English. I'm following through interpretation. I love Mr. Housefather, but boy, does he speak quickly. Can he please slow down a little bit so I can follow his very interesting questions?
Absolument. Je vais parler.
Merci, Mr. Housefather.
So goes your 10 seconds.
I will speak more slowly, absolutely. Slow down. I don't want to take away from your time.
Thank you all for being here. I think that we have a general tension in this law, as you've rightly pointed out, between the goal to be as safe as possible and the goal to respect privacy rights. And we have to find that middle where most people are comfortable. I don't think we'll ever find a situation where everybody is going to agree as to the details of the bill, but I think we have to try to find that reasonable point. I mean, I think we start from a premise where the bill is laudable in the sense that certainly it deals with some of the flaws in C2. The bill is something that is really needed in terms of law enforcement having access to information that, technologically isn't dealt with under current law. But as everybody here said that there's concerns that you've expressed. I think one of the things, though, that I've noted is a real discomfort with the idea of regulations. I would point out, like, there's a suspicion as to what's going to be in the regulations, and then we're hearing hypotheticals of what might be in the regulations or how orders might be used. And some people will believe more in trusting the government and saying that they're going to act reasonably, and will say the charter still applies, and there's still judicial oversight over it, and other people will say no, I just trust what because I'm not going to trust it unless it's written in front of me in the bill. So I get all that. I want to deal with one issue that I also have expressed some concerns about, which is the interplay between systemic vulnerabilities and the orders. Because the way I also read the bill is that there's an exemption to the company having to do it if it creates a systemic vulnerability. And I understand we might need to look at the definition of systemic vulnerability. But then in an order, the company is obliged to carry out the order. Mr. Geist, you had talked about that issue. Could you just express again the way you would amend the bill to deal with that issue?
Yeah, so thanks for the question. And I guess I would highlight a couple of things. I think first, it is essential that we get greater specificity around this issue with a more clarity around what that definition sounds like. I think that the concern that many have expressed about what could this mean and the implications, this is so serious in terms of what it means for our cybersecurity and for people's privacy that I think we owe it to everyone to ensure that it becomes clearer. And respectfully, I think there is good reason for people to listen to the debate and think that, in fact, some of those concerns are warranted. I've heard, for example, during the House debate, the Secretary of State for Combating Crime talk about this being a first step. And I walked into the hearing just before with the police officers talking about wanting metadata for 2 or 3 years. Is that the next step? Beginning to expand this into multiple years. I don't know, but I know that there are real concerns. So we need, in answer to your question, we need far more specificity around the definition to make very clear that this is not touching encryption. This is not, there will be no orders that will create systemic weaknesses. That's a clear starting point.
Basically, though, saying that sections, 5 and 7 are subject to section 10. And I understand also adjusting the definition of systemic vulnerability.
Yes, and that was my other element. There was two. It was the definition, and it was this inconsistency that we've got in the bill that talks about, on the one hand, the ability to raise concerns, but on the other hand, language that suggests you have no real ability to challenge or at least avoid an order.
So in that one I'm very sympathetic to. I do want to just mention something, because I have less agreement with raising the grounds to reasonable belief from reasonable grounds to suspect. And I just wanted to point out that the conditions for making the demand say the peace officer or public officer may make the demand only if they have reasonable grounds to suspect that, and then an offense has been or will be committed under this act or any other act of Parliament, and that the confirmation that is demanded will assist in the investigation of the offense. I think the combination there does create a situation where there is a reasonable burden determined by the totality of the circumstances that makes that threshold to be relatively reasonable in this context. I understand, though, the idea of limiting what the production order could actually deal with, but should we do that? Should it be, for example, this person's name, this person's address, all the stuff you used to be able to read in a telephone book, right? And not necessarily every particular service the person had, for example. Would you then agree that that was a reasonable threshold? Yeah. You, Professor Diaz, because I had already asked Mr. Geist.
Yes, thank you for the question. So I think there's two parts to this. First of all, the language that you cited at the opening, the preamble, that's standard language, and so when it's challenged and courts are assessing whether it's a reasonable law under Section 8, they are going to be looking at really the scope of it, in addition to the grounds. And so one part of the whole question is reasonable suspicion too low even for just the name and address of the subscriber? So that's one question left open in the wake of Spencer. But to reiterate a point Professor Geist just made a couple of minutes ago, in Spencer, the court said, we have a high privacy interest in the name attaching to our subscriber information because it ties us to a whole search history. So it's a high interest. So the court didn't say this, but it was sort of intimating that probably nothing less than a warrant on probable grounds would be reasonable, but it wasn't asked that question, so it didn't have to answer.
Sorry, Professor Diab, but I have to cut you off there. Ensuite, Madame de Bellefeuille pour 6 minutes.
Madame de Bellefeuille for 6 minutes, please. Thank you very much, Mr. Chair. Mr. Geist, I hope, is that pronunciation good? I hope so. You said that keeping metadata for a year is too long, that 30 days could be reasonable, and if there are reasons to believe that there is criminality, to get a mandate and extend that period. That's what I understood. Is that correct? Is that what you recommended?
What I was suggesting, in a sense, what I was trying to put forward is, there is always the ability for law enforcement, if it needs this information as part of an ongoing, lengthy investigation, to seek the necessary order to have it preserved. The issue that law enforcement, I think, in this context is identified is what happens. You don't know what you don't know in some circumstances, so you don't know that you might need it. And so there is this desire to build this giant haystack of information because maybe you need the needle at one point in time. It seems to me that, of course, that haystack is comprised of people who have done no wrong, they're suspicionless, and it raises for them real privacy-related concerns. So is there some kind of mechanism that we can find in the spirit of trying to address law enforcement's concerns that will allow, on a rolling basis, some of this information to be retained, but quickly discarded after an appropriate period of time? So I heard in the last panel, I think one of the members of the law enforcement was asked for a use case and talked about a missing person. Wouldn't it be good to be able to get that information? Respectfully, you don't need to retain everybody's metadata for a year for someone who's gone missing. I would think, frankly, 30 days is more than enough to realize the person's missing, and then if there is a need to try to obtain other metadata, you can get the order to get it.
Thank you for that answer. I think that's very clear. We all care about Bill C-22, and we've all committed to working together and to improve it. So if you would propose an amendment, a very specific amendment or improvement, we would welcome anything from you, especially if you want to have it translated into both official languages. Next question. I learned, and unless I misunderstood, that in the U.S., rather in Europe, the retention of metadata is done in cases of serious crime, and Europe is much more careful about protecting privacy rights. And that in the U.S., it's not clear that they keep metadata for a very long time either. Do you feel that with C-22, Canada would be more intrusive into the private lives of Canadians compared to Europe and the U.S.?
Thank you for the question. Europe has had now a whole series of cases, both at the European level and at the national level amongst a number of member states, that have found some of the initiatives around mandatory metadata retention to be disproportionate. And so you get these cases and countries begin to respond. And so it is a bit of a mix in terms of length and also under what circumstances, for what particular instances one might be able to retain that information. But it's very clear that European courts are uncomfortable with what I would characterize now as a Bill C-22 style metadata approach of retaining everything for a year. And as you heard in the last panel, in the United States, we don't see that retention at all. So I think it makes us clearly out of step with some of those countries, but even perhaps more importantly, for the purposes of creating legislation that will sustain a potential challenge, I think it's out of step with where the Charter is.
So what I understand, Mr. Geist, is that police chiefs and the authorities have told us that they want to be aligned with the Five Eyes. But what I'm hearing from you is that the metadata retention regime is would be broader here than amongst our Five Eyes allies and European countries. Is that what you're saying?
You can always find examples that where it's consistent or otherwise, but to the extent to which we heard just before the talk about a lot of north-south related issues with respect to crime. In the United States, we don't see these metadata requirements. In many European countries, we don't either, and so Canada would certainly be open to creating a system either without this at all, or if they did for a very short period of time, working in conjunction with the ability to get quick freeze orders to ensure that you could retain it for longer periods. And I see little reason to think that that would not be viewed as doing our part within, as compared to our allies.
Pourquoi pensez-vous, Professor Geist,
Professor Geist, why do you feel that the government, in its definition of electronic service providers, why is it giving itself so much leeway in the regulatory area? Why?
I wish I had a good answer. I guess I mentioned off the top that this is an issue that I've been focused on for decades now, and the experience is that governments from both parties, whoever's in power, when working with law enforcement to flesh this out.
Professor.
I'm sorry, Ms.
The time is done. Madam. Now for 5 minutes, please.
Thank you, Mr. Chair. Mr. Fraser, I appreciate you being here today, and my questions will start with you. Yesterday, let me just start with the difference between what's intended and what's allowable. And I think most Canadians would not argue with what the intention of this bill is. And, many times when we ask questions of the department, both of justice and public safety, they would rely on the statement, that's not the intention of this bill. And my concern is more, what does it allow versus what does the bill intend? Yesterday, the Public Safety Canada on social media platform X posted this and said, fact or fiction, ? Bill C-22 will require electronic service providers to create backdoors to their systems. Fiction. C-22 would not require backdoors. And you responded on X saying this, fact, there is nothing in Bill C-22 that would prevent the ordering of backdoors given the enormous powers granted under Sections 5 and 7. Could you elaborate on that concern for the committee?
Sure, absolutely. And I think that's one of the big issues with this bill. And when you talk about the intentions of the bill is in two parts, and they do two very different things. One is about authorities, and the other is about capabilities. But if you look at Section 5 and the list of things that the minister can make, or the Governing Council can make regulations about, or Section 7 and ministerial orders, they are written extremely broadly. First, I would call your attention to can make regulations including all the things in A through D, which means it can do more. An implicit grant of authority. But there's within paragraph A could include backdoors. Within paragraph B could include backdoors because they can require the installation of devices on ESP's infrastructure. But there's nothing else in the bill that prevents that from happening other than the goodwill of the minister, the goodwill of the intelligence commissioner, and that's that. And particularly, I'm very, very concerned about these secret orders because the minister has the power to do to any telco or any ESP, it's not even telcos, any electronic service provider, any of the things that could be in a public regulation, at least the regulations are going to be published. We'll go through a process. People can see them. But secret orders that can include backdoors because it certainly doesn't preclude it. And the definition of systemic vulnerability doesn't protect encryption in any meaningful sort of way. And so you take those two things together, the guardrails simply are not there. The only guardrail is the Charter of Rights and Freedoms, which will have to have litigation in order to, I'm afraid the government is setting themselves up for failure if they pass a bill that goes too far, that violates the charter, that's going to be found to be unconstitutional. Better to get it right.
Thank you. We've talked about that a few times about getting this bill right versus racing, to just get it passed. So in terms of intention versus what's allowable again. So if the government truly has no intention of compelling backdoors or weakening encryption, can you think of any reason why there would be any reason not to clearly and explicitly prohibit those activities in the legislation itself?
I can't see any reason why we shouldn't include those guardrails. Guardrails are absolutely essential. And part of the reality is that intention really doesn't matter today, because what is going to become law is what is written in that statute. And the minister is going to change at some point. The government is going to change at some point. And we can see significant changing tides south of our border. And if those powers exist in a completely different political environment, that can absolutely be used against the citizenry. There's the expression turnkey totalitarianism, which is something that causes me some concern.
Thank you very much. I appreciate that. Dr. Geist, in your May 2026 article, Willful Blindness, and there's a question mark on that, you argued that the charter statement, which the Department of Justice requires the Minister of Justice to prepare, largely ignored some of Bill C-22's most constitutionally vulnerable provisions. In your view, why do you think the government avoided meaningfully addressing the sections of the bill that are most likely to raise serious charter and privacy concerns?
Well, thanks for the question. I mean, I don't have a good answer for why they did it or why they didn't address those issues, but I will say that I think it raises real concerns. If the reason is they don't believe that issues, let's say, around mandatory metadata retention raise charter issues, and so felt there was no need to include it, I think both that is inaccurate with respect as a matter of law, but I also think it suggests, as we've been saying, that this legislation is going to be challenged quickly, and I think that there is a real risk that provisions like that get struck down.
Thank you, Professor Geist. Moving next, we have Mr. Zuberi for 5 minutes, please.
Thank you, Mr. Chair, and the witnesses for being here today on this important legislation. I wanted to start off with Professor Geist. You were answering a question by one of fellow parliamentarian, Madame de Bellefeuille, around privacy and how other Five Eyes and European countries handle that issue. But I'm curious about judicial oversight and how do Five Eyes and European countries approach judicial oversight with respect to a comparative analysis on C-22?
It's a good question, and candidly, I don't have a complete answer for you in terms of sort of, let's say, the production orders or the subscriber information that we've been focused on. My area, perhaps one of my colleagues on the panels do, my area of focus has been primarily on that intersection between what happens in the network environment, providers, and privacy. And that's where it feels like we're out of step.
Okay. If anybody else has a comment on this, or else I'll pass to my next question. We know that in policing that there have been disproportionate impacts with respect to racialized communities, Indigenous people, and different social movements. Do you have any concerns around impacts being different for specific communities within Canada as it applies to this legislation?
Well, I mean, I could start, and perhaps others can proceed. I have concerns. The concerns that we've expressed. I think we'll run the risk of undermining the trust. I referenced that towards the end of my remarks. Undermining the trust between the public, their providers, and frankly, law enforcement itself. So when you talk about communities where some of that trust may have been even now strained, the notion that we are creating frameworks that lessen the safeguards that exist in terms of the standard to be able to obtain information, and even the base knowledge that as people become more aware of the implications of some of these provisions, that who they speak with, like from on their devices, where they go, and how they engage, all of that information being collected and retained for a year, I don't think that increases the level of trust that people have, both with their providers, knowing that their providers have this information, and then layering on top of that the fact that the providers have been compelled to collect that information, and then enveloped with secrecy around what might take place with some of that kind of data. I think all of this undermines the trust that exists between the public and the various kinds of authorities that we want to, I think, enhance the level of trust with.
Right, and you were talking earlier about, or at some point you've spoken about targeted quick freezes instead of the current approach. Do you have any commentary you want to expand upon that concept a bit?
Sure. So, I mean, the basic notion between a quick freeze, which is by and large what takes place today, is we should probably just back up to note that there is no commercially viable reason for providers to retain metadata for long periods of time. There are risks. We've talked about those risks. Create that big haystack, so to speak, and you create a ripe target for hackers or for others who might seek to gain access to it. It's a treasure trove, potentially, of information. But beyond that, it's expensive, which may render some providers less competitive, thereby increasing prices that Canadians face for their communication services. And so, by and large, they don't do it. And what they do, though, is create a scenario whereby they will respond to orders requiring them to retain this information while an investigation is ongoing. And so what I had suggested was, can't we find a way of marrying that system that does allow for, on that ongoing basis, to retain that data with a system that, for a very short period of time, if needed, allows for that retention that then gets quickly flushed, so that you can have, in those very small minority of situations where you need that metadata retained for a long period of time, it's retained. But it's only retained where you've got an active investigation, not against all Canadians.
So in the 30 seconds that's left, do other European and Five Eyes have the approach of what you're describing?
The quick freeze is the common approach that we find in jurisdictions that don't have mandatory metadata. So it's not as if law enforcement can't get metadata in other places. They can, but with appropriate oversight, using sort of that kind of quick freeze model.
Thank you very much. Madame de Pelfay, vous avez 2 minutes.
Madame de Bellefeuille for 2.5 minutes. Thank you, Mr. Chairman. I will follow up on the question I asked earlier, Mr. Geist. There's no clear definition on electronic service provider. So, do you feel we should tighten that definition? So the electronic service provider definition, or main electronic service provider?
And Mr. Fraser, I know, spoke to that, and he could perhaps elaborate around why that very broad definition encapsulates far more than I think most people would realize, given just how broadly it's defined. I did want to return to your question that I didn't have the chance to fully respond to, where you asked why go so broad. And I do think, and I say this with respect, as I look back on the many years of lawful access debate, it is invariably the case that law enforcement seeks as many powers as possible, and one can understand why. They would like to ensure that they can do their job as effectively as possible. But just because you can demand that very broad approach doesn't mean that the government of the day ought to acquiesce, and certainly not Parliament once it's had the opportunity to study the implications and the trade-offs that exist when that happens. So we saw it, frankly, in Bill C-2, where there was clear overreach with respect to warrantless access to information from anybody providing a service in Canada. People said, hold on a second, that goes too far. And thankfully, the government listened on that issue. But we still have other issues where I think we need to recognize it does go too far, and we need to scale back, recognizing that we'll still address many of law enforcement's concerns and needs.
Donc, professeur, vous seriez peut-être...
So, Professor, can you perhaps help us define the definition, and perhaps we just need to be more precise in that?
Well, I think as a starting point, this notion of sort of people engaging with information or information services in that way, as David Fraser noted, really does encapsulate everyone. If what we're really talking about is that you've got, and the vision is, and it's difficult because it's just speculating, if it's just core providers are the major telcos, but we're thinking about others that provide what might be viewed as parallel type of services, that's what I would have thought an electronic service provider might be, but that's not what we've got in the definition right now.
Thank you very much, Professor Geist and Madame de Belfay. Now we go to Mr. Baber for 5 minutes, please.
Mr. Fraser, you're a lawyer in good standing with the Law Society of Nova Scotia?
I am.
Practicing for over 25 years?
As of last month.
and you're a technology and internet lawyer with the McInnes law firm. I also understand you're a prominent speaker on technology and internet issues. So I came across one of your YouTube videos on this law that we're studying now, C-22 lawful access, and I'd like to provide the committee a quick transcript of your remarks. If Bill C-22, the Lawful Access Act of 2026, became the law, the Government of Canada will be able to secretly order Apple to build in a capability into its infrastructure to allow Canadian law enforcement and national security folks to track every iPhone, every iPad, every Apple Watch, every Apple AirPod, and every AirTag in real time. They'll now be able to require Apple to confirm whether they provide you with any services. Then, law enforcement can go to Justice of the Peace and get an order without actually believing that a crime has been or will be committed, requiring Apple to hand over every device identifier for every device that you use with their services. That's the digital ID for your phone, for your iPad, Apple Watch, AirPod, Apple TV, Apple AirTag. With that information, they can go back to the judge and get an order, again, without actually believing that a crime has been or will be committed, requiring...
Mr. Baber, please. Mr. Baber, please, if you could just slow down a shade. Please.
I'm almost finished. Requiring Apple to give them the moment-by-moment location of all of your devices. Oh, and that secret order also required Apple to keep your location history for a full year so cops can get that too. So what's the problem, Mr. Fraser?
All of it. All of it. Certainly, the judicial oversight, I have very few concerns with. The threshold is obviously important. But if you take a look at all of these pieces as they go together, so Part 2 can require an electronic service provider, undeniably Apple is an electronic service provider, subject to a secret order to preserve metadata, location information, all that sort of stuff, and even build in new capabilities to their devices. That's under Section 7(2)A and B. And then you look at, so once that information exists, you can go to a judge and get an order on reasonable suspicion related to confirmation of service, then reasonable suspicion related to basic subscriber information, then reasonable suspicion in order to get metadata, tracking information, transaction information that they've been required to save. So this is an entire package or a potential entire package that we need to look at holistically and in detail.
Without actually believing that a crime has been committed, without swearing an affidavit saying, I believe that a crime has been committed, and therefore, I, Your Honor, get a court order. I'd like to dispose of some of the legal arguments that the Liberals make, and I'd like to get specific, if I may, with Mr. Diab. One of the arguments that is made on Section 8, and that's the arbitrary seizure, because what the government's proposing to do is to seize metadata, all of it, seize all of it, and order that be held for 365 days without knowing or suggesting that any offense has been committed. But there is some jurisprudence on Section 8, arbitrary search and seizure, that suggests that seizure requires a production. And here, we have no production. How do you respond to that?
The seizure is in the holding of it. It's in the recording.
The seizure is the fact that information is being held. And the fact that it's not held by the cops, but held on behalf of the cops by order of government is what makes it seizure, because you have government compelling private sector to hold on to the information. On to Professor Geist. It's very nice to see you in your non-Twitter persona. Professor Geist, I have a major concern specifically with the language of who can be bound by these orders. And specifically, it's the electronic service providers that can be compelled by a minister to come up, design a system, backdoor, etc. And so I look at the definition of service provider. It's Part 2, Section 2, the definitions. It's basically anyone that provides electronic services to persons in Canada and does business in Canada. So then I go and I look to see the definition of electronic service, and it means anyone that involves in creation, recording, storage, processing, transmission, reception, or emission of electronic communication. Well, it sounds to me like any law firm would be sending emails or receiving emails through its server, any bank would, any doctor's office would, and yet we hear from the Liberal officials that only internet companies are subjected to this, but that's not what this legislation says.
No, that's consistent with the question that was raised earlier. No, it clearly is not what it says at the moment. It's clearly far broader. If I might, you asked.
I'm sorry, you were just about to give us a brilliant thought, Professor, but that brilliant thought will have to go to Madame Dandurand if she so chooses for 5 minutes. Thank you.
Yeah, I'd like to hear that brilliant thought.
I think it's way too hyped at this stage. But what I was going to say was, you asked that question with that long list of related to Apple and this notion of, well, what's the problem? As if the problem, of course, is look at all that data that might be ultimately retained and potentially accessed. But there is another problem here. That is the problem that by layering in some of these rules, these companies may well either remove some of the services that protect Canadians. We've seen that with Apple in the UK. Or some may choose to exit the market altogether if they are unable to meet the kinds of standards that they expect of themselves and that their customers expect in terms of the kind of privacy that they provide. So when you layer in a very broad definition of an electronic service provider with very broad demands that may be inconsistent with where the company's at, you create an environment where Canada may well be an outlier and companies either stop providing particular kinds of protections or service altogether.
Merci beaucoup. Et sur ce,
Thank you very much. And I will let my colleague, Mr. Zuberi, continue with a brief question.
Mr. Diab and Mr. Geis, professors, if you have anything that you'd like to add that you haven't yet had the chance to add.
Yes, maybe just one thought to put out there is whether the hypothetical that has been floated a number of times to justify metadata, the metadata preservation power, the kidnapping of the 14-year-old girl, the trafficking, et cetera, whether that's an effort to recycle something like the ticking bomb scenario 20 years ago. So we heard a lot about the ticking bomb scenario as a justification for torture. And I want to be careful here, but the idea there was you took an extreme situation and you used it to justify, to normalize powers that are otherwise just beyond the pale. This is, I think, what the committee should think about, whether that is something that is happening here. We're taking an extreme scenario. We're taking something that is, if it does in fact happen, is very rare and unusual, and we're saying that all Canadians should give up a significant amount of freedom, of security, of privacy, to enable law enforcement to be a little more effective in this remote scenario.
I appreciate that. And just to continue along this path, can you comment, and if you can't, that's fine, but can you comment on, right now, Canadians have a reasonable expectation of privacy when it comes to talking with a friend. That is a private conversation. The fact that it happened is a private conversation. Can you comment about how our expectation of privacy will inevitably have to adjust because of this type of collection?
So when a law is challenged and the court is asked, is this a reasonable law under Section 8? Does it allow for a reasonable search or seizure? That's not the way they approach it. What they ask is they stand back and they say, when two Canadians are communicating, you look at the restaurant, for example, would they think it's reasonable to assume that their conversation is private? If they are texting one another, would the reasonable Canadian assume that their texts are private? That's the way they do it. So the question here, when it goes to the Supreme Court of Canada eventually, would be, would the ordinary reasonable Canadian assume that the record of their texts over the past year, the record of their movements, would remain private in the sense that they were not recorded by the state for a law enforcement purpose, for the potential that these random Canadians could have been committing a crime. And I mean, you ask yourself the question: if you were a judge, would you think that's a stretch, or would you say, of course we don't want our movements recorded?
With respect to this collection, and there have been many concerns raised around the unintended uses of this, or the unintended capturing by unwanted actors. Do you want to share any concerns around that, about how those who we don't intend to have this information can have it, whether or not it's within the companies in question or hostile actors, be they foreign states, be they hackers, etc.? Please, if you have something, share.
I'll respond this way. I appeared yesterday before a Senate Committee on AI, where much of the focus was on cybersecurity. I have to say, I find it positively dizzying to go from one committee where we're talking about things like Claude Mythos and the desperate need to ensure that we've got as strong cybersecurity as possible, to then walk in and talk about legislation that knowingly would undermine that security. Make it make sense.
Thank you very much, Professor Geist. I apologize. I do want to exercise my prerogative as chair, because there's one thing I think that we're going to hear about in the next round that I really do think is very important. If I could ask you a very brief second, just 15-second response. You had mentioned 30 days for metadata would be appropriate. Oftentimes, there's not even an investigator in like an internet luring case assigned at 30 days. Bearing that in mind, would you think that, what would you think about 90 days, given those types of crimes, or to address those types of crimes, or the metadata that would allow to address those types of crimes?
Well, I guess the best way to respond to this is that too much of the policymaking associated with lawful access has not been evidence-based. It's the occasional anecdote without strong evidence. And so it seems to me, if we are in the realm of trying to say, okay, what's the appropriate amount, a year clearly being way too long, what we need is far more evidence, frankly, about when are there instances where that metadata is actually needed, and how long does it usually take before you might be able to get that order?
Well, we will try to get that in the following panels. Thank you very much. Thank you to our witnesses. We will suspend briefly. Very much. We are going to lead off. I know that there is food here. So to our witnesses, this is a fairly lengthy meeting. So if you see people, this is a 4-hour meeting. So to our witnesses, if you do see people dining, please do not be put off by that. We are now into our third panel. I want to invite our next panel of witnesses here to speak. I'm sorry, I was on the wrong page. From the Canadian Centre for Child Protection, Monique St. Germain. From the Canadian Chamber of Commerce, David Pierce. And from the Peel Children's Aid Society, Mary Beth Mullenkamp. Thank you to all the witnesses. You have 5 minutes for an opening statement. Ms. St. Germain, we will hear from you first, please. Thank you.
Thank you very much, Mr. Chair, and to this committee for inviting us to participate in this study. My name is Monique St. Germain. I am General Counsel for the Canadian Centre for Child Protection, a national charity that works domestically and globally to reduce the incidence of missing and sexually exploited children. We operate cybertip.ca, Canada's tip line for reporting the online sexual exploitation of children. In 2025 alone, we received 28,000 reports. We also operate Project Arachnid, a platform that prioritizes the removal of harmful child sexual abuse and exploitation material. As of this month, Project Arachnid has issued 141 million notices requesting CSAM removal. On a daily basis, our agency directly witnesses egregious privacy violations on children whose child sexual abuse material is circulating online for the world to view. We hear directly from children and families impacted by online crimes like CSAM, online luring, and extortion. We welcome the measures in Bill C-22, particularly the confirmation of service demand and subscriber information production order. It's been over a decade since the Spencer decision left it open for Parliament to enact a reasonable law. We hope this time we can finally get there. In the intervening years, we have witnessed a number of growing threats to children, including an exponential increase in CSAM online. StatsCan figures show CSAM incidents have quadrupled from 2014 to 2024. Then there's online luring. Reports to CyberTip surged 344% between 2020 and 2025, and StatsCan has this crime going up 65% in 2024 over 2023. And sextortion is another big issue. CyberTip has received over 14,000 reports since 2020. And even though crimes against children are through the roof, StatsCan data reveals that in 2024, charges were later recommended in just 24% of all sexual offenses against children online, and in only 6% of CSAM incidents. We have to ask ourselves, why? This is obviously complex, but it has to be acknowledged that offenders are increasingly using sophisticated tools like burner phones, bulletproof hosts, VPNs, and networks like Tor that hide IP addresses. Some apps are blatantly and intentionally designed for anonymity. Offenders are able to rapidly change their digital identities through fake accounts. It's very common for offenders to use multiple apps, devices, and accounts. Unraveling that web is incredibly complicated, and on top of that, some of these investigations involve multiple jurisdictions and service providers. Record keeping and cooperation amongst these providers varies widely. This has got to be having an impact. At our agency, we are now at the point where nearly 1/3 of contacts to cybertip.ca or our support services come from children seeking help. These are just the children who come to us, and often only when they are in crisis and in some cases suicidal. By the time these children feel able to reach out for help, the evidence that might help police identify their offender could be gone. Even a single offender left unchecked can inflict an enormous amount of harm. As just one example, an Alberta offender posing as a female teenager was able to lure 92 children. We wish to address one specific area of the bill we would like to see changed. We believe the confirmation of service demand should include basic jurisdiction information, such as province and municipality. Having this information is critical, especially at the outset of an investigation when the available information is limited. Knowing the jurisdiction will help ensure the right policing agencies are involved and that production orders are brought forward to the right court and can help police be much more effective in their investigation. In closing, Canadian children have been forced to pay a very steep price as this debate rages on. Past failed efforts at lawful access reform are a powerful reminder of how long children and families have been waiting for action. We want police to be able to act. We need them to have the tools to do so. Thank you.
Thank you. On to Mr. Pierce for 5 minutes, please.
Great. Thank you very much. And thank you for the opportunity to be here today on Bill C-22, Lawful Access. At the Canadian Chamber of Commerce, I'm here on behalf of our 400 network chamber partners and boards of trade across the country, our 200,000 combined members, and more than 100 industry associations. I'm also here as a father. I can share that many representatives from Canada's digital companies also have families. We all want to ensure that law enforcement has the tools it needs to pursue criminals, especially online. I'd like to express our appreciation to the Minister of Public Safety and the Minister of Justice and their teams for the extensive back and forth over the past year. The amendments made to C-22 Part 1 addressed many of the industry's concerns, and we thank the government for acting. But when you compare C-2 Part 15 and C-22 Part 2, it's clear the government doesn't share the same concerns as the vast majority of our members at the Canadian Chamber of Commerce. I've worked in and around cybersecurity for years. I don't understand why we treat cybersecurity differently from other crimes. If a business is hacked, the business CEO must apologize. The liability is on the business, even if hackers are state-sponsored. Yet our discussions here today are not about how we can support business to further protect their systems and our data. Instead, we're talking about obliging them to install devices, open their digital doors, and give access to information to authorized persons, essentially on demand.
L'interprète n'est pas en mesure d'interpréter.
The witness is speaking so quickly the interpreter cannot follow.
Mr. Pierce, if you could please speak a little bit slower. We do have interpretation, particularly when we're reading, just to all witnesses and all members. When you are reading, we do tend to read a little bit faster, so please just bear that in mind for everybody. Thank you.
Absolutely. No, I'm happy to. Let's imagine this law is on the books. In a year or two, imagine hundreds, maybe thousands of investigations across multiple national law enforcement agencies and federal departments on all of our digital systems. Who's managing all those secure keys? Who's accountable for patching and updating those systems to make sure that they are secure. If I leave you with one message today, it's this: the business community supports production orders. We support urgent 24-hour production orders in exigent circumstances. But we are very concerned at the prospect of unfettered access by a government-authorized person to pull information from encrypted, secured systems. What's also puzzling about this debate is that I've had the privilege of working with some of the most talented lawyers in the country. And there is a debate right now about whether or not C-22 Part 2 requires a warrant. It is critical that the powers in C-22 Part 2 be amended to clarify this important point, especially on subsections 5, 7, 14, and 20. On the discussion of metadata, this will impose significant costs, millions of dollars, on businesses, not just in the infrastructure to retain the data, but to manage it securely, and that it's in a usable format for law enforcement. As soon as you store large volumes of sensitive data, it becomes a cyber target. As soon as data is retained, it's a target. We recognize the importance of non-disclosure orders, but these should be limited to court-authorized actions tied to national security risks and active investigations. C-22 could also penalize successful Canadian companies that operate here in Canada, but also have operations in the United States and Europe. If you are an electronic service provider based in Canada today with customers in the United States and Europe, complying with parts of Part 2 could put you offside with law enforcement and regulators in those jurisdictions. At a time when businesses are already facing tax competitiveness pressures, tariff uncertainty, the broader economic risks that we're all facing, adding another layer of regulatory burden on Canadian companies at this particular time may incentivize them to relocate. Finally, with regards to the definition of core provider, without an amendment to this section, it potentially captures the vast majority of Canadian businesses who communicate or provide an electronic service. In closing, the business community very clearly has signaled that they're concerned about C2 Part 2 especially. I think we all trust that the current Prime Minister, the Minister of Public Safety, the Minister of Justice will use the measures in this law in a way that's appropriate and as they've said. And I'm sure the public servants who are at the committee on Tuesday would do the same. They seem to be very honest and reputable people.
Thank you very much, Mr. Pierce.
Thank you.
We'll now move on to Ms. Molenkamp for 5 minutes. Thank you.
Mr. Chair and members of the committee, thank you for the opportunity to appear. My name is Mary Beth Molenkamp, and I'm the Chief Executive Officer of the Peel Children's Aid Society. Peel Children's Aid is a mandated child protection agency for Peel Region, including child protection responses connected to Toronto Pearson Airport. We also lead alongside our partners Encourage, Peel's anti-human sex trafficking integrated service hub, and CWICE, the Child Welfare Immigration Center of Excellence. Through this work, we see how trafficking, immigration, housing instability, and cross-border movement intersect with child safety and reflect broader provincial and national trends. That experience gives us a particular perspective on Bill C-22. Bill C-22 responds to a real challenge: whether lawful systems can move quickly enough to protect children in a fast-moving, digitally enabled environment. Children can be groomed, isolated, threatened, moved, and controlled through digital tools faster than systems can identify risk and respond. Timely, lawful access to digital evidence can help find a child, identify the adult causing harm, prevent further exploitation, and support coordinated intervention. At the same time, safeguards are essential. The use of these tools must remain grounded in lawful authority, appropriate oversight, clear thresholds, privacy protections, and respect for children's rights and dignity. The child welfare system holds a difficult but necessary tension. We are responsible for protecting children from harm while also protecting their privacy, voice, and civil liberties, and both matter. Children and youth involved with child welfare often already experience high levels of system involvement. They are disproportionately represented among victims of sexual exploitation and trafficking. Many have experienced trauma, abuse, neglect, instability, and disrupted relationships. Traffickers exploit these vulnerabilities. What begins as connection can quickly become coercion and control. Some youth are drawn into other forms of criminal exploitation, including auto theft, fraud, drug movement, or recruiting other youth. These children are often being manipulated, threatened, and isolated. In Ontario, as in other jurisdictions, human trafficking is recognized as a child protection concern. We have a clear role in assessing safety, supporting caregivers, collaborating with police and community partners, and protecting children from ongoing harm. Increasingly, our efforts focus on identifying traffickers and exploiters as the individuals causing harm, rather than viewing parents and caregivers as failing to protect. Traffickers exploit gaps between systems and jurisdictions. They exploit delays and digital platforms that move faster than our legal and service responses. The average age of recruitment into sex trafficking is estimated to be at 13 years old. At PLCAS, we have supported children as young as 9. Last year, our agency identified more than 200 cases where a child or youth was suspected of involvement in trafficking for sexual exploitation, and yet we know this is significantly underreported. Often, a child may only know a trafficker through a phone number, social media handle, app, vehicle, hotel, or email address. Those fragments matter. They may be the difference between not knowing where to look for a child and locating a child. The value of Bill C-22 for child welfare is indirect, but it's important. It may help our police partners obtain lawful digital leads that child welfare agencies, trafficking hubs, survivor services, and community organizations can translate into safety planning, protection, and survivor-centered support. Exploited youth must be treated as victims and survivors, not offenders. Digital information alone will not make children safe. Safety requires coordinated systems, including child welfare, police, survivor-led supports, Indigenous and culturally specific services, immigration, expertise, housing, and mental health supports. Used lawfully and with safeguards, Bill C-22 may help partners locate children sooner, disrupt exploiters faster, and strengthen collective efforts to protect children and youth. Thank you.
Thank you very much, Ms. Molenkamp. I want to thank this panel of witnesses. I will be beginning the first round of 6 minutes, starting now. Ms. St. Germain, you probably don't remember me, but I did consult with you when I was writing the bill to change the name of child pornography to child sexual abuse and exploitation material. And I first became acquainted with your work when we both attended the same conference, which was the BC ICE provincial strategy, which for those who don't know is a number of police officers who are involved in internet and child exploitation. And the RCMP has a specific unit in Vancouver, and a number of people from all sorts of agencies gathered, so I really appreciated your interventions there. One of the things that we were talking about in the prior round is how long it takes for an investigation to kick off. So when I was prosecuting an internet luring case, for instance, a lot of people don't realize, but a service provider, let's say Facebook, they realize that their software picks up that there's an attempt at luring a child. Then that goes to Washington, D.C., as I recall, or it used to anyways, to the National Center for Missing and Exploited Children. And then I believe it then would go to national headquarters at the RCMP, and then it would go to whichever province. I think I have that right. Hopefully I do. Is that somewhat accurate?
Yeah, I mean, assuming that this is coming through mandatory reporting in the United States.
Yes. Yeah, exactly.
That is how it goes. Yeah.
And that process takes time. It takes a fair amount of time. And one of the points, or one of the things I asked one of the legal experts on our previous panel, when we're talking about data retention, well, how long do we need to retain data? Because I don't think anybody thinks that data should be retained indefinitely. You're a lawyer. You understand where people come at it from. But we also have to look at how long data is needed to be retained in order to actually have an investigation. So in your experience, can you tell us how long it takes for an investigation to actually kick off to the point where somebody would look at it and go, wow, we need this, or we're missing an IP address, or there's this evidentiary gap that if only we had this, or this would help us catch a child predator? Hopefully I'm being clear on that question.
Yeah, I understand what you're asking. I'm not sure that I'm the person that you should be asking it of. We're not police. So the role that we play is very distinct and separate from police. So we will get tips from different places and we pass things on to police, but then the investigative process that they follow is within their knowledge. So what we do know from where we sit in the continuum is that oftentimes when the tips that are coming into us from Canadian children and families can't be acted upon because by the time the information gets through to police, there may not be sufficient information for them to be able to obtain. And there have certainly been delays in terms of getting subscriber information to be able to link the information they have to an actual location that they can actually then start to investigate who. Because an IP address, for example, may lead to an individual house, but within that house, there may be 4 different individuals living there. So there's a whole process, and every step in the process is a narrowing and a getting closer to who the actual person is. So on the issue of metadata, what I can understand from the bill is that this is being left to regulation to kind of go through what metadata is being captured, saved, and for how long. And that is an important process in order to clarify what are the pieces of information that are going to be helpful. Certainly, what we see in the courts is that that information is critical in terms of linking an offender to a particular piece of activity on the internet.
I do appreciate that. I mean, one of the greatest challenges I had or that I saw was putting the person who's in the prisoner box behind the computer screen or behind the phone, because you have to have a piece of evidence that is linked in every spot. Perhaps we'll ask you this. How long does it generally take from the time that you get a tip to the point where something can be sent to a police agency?
Right. So our role is to turn around the tips as quickly as possible. So we will process the information, and if it appears to reveal that it is a criminal act, then we will send it to the police agency that we believe has jurisdiction. So we will use tools to try to figure out what we can based on what we have, but we're not necessarily getting things like IP addresses or anything like that. We're getting what the child is saying the username is of the other person, or they're describing what is happening. And so we're trying to get the police maybe in the place where the child is, unless we can figure out something about the offender. So we turn it around fairly quickly. Within 48 hours, we will have something turned around, if not sooner than that. We certainly try to prioritize and get through everything very, very quickly.
And then that username is then used to get a production order, ideally, which is on oath or affirmation, which is part of what this bill's about. Ms. Molenkamp, do you have anything to add on this based on your expertise?
Can I just ask you to repeat the question?
I was just asking about how long, in your experience, to kick off an investigation. Do you have any experience with how long it takes? I know you're not a police officer, but I'm just trying to gauge that.
Yeah, well, in the child protection system, we have eligibility that we consider around the level of risk to a child. So we may determine that we need to go out and see a child within 12 hours, or we may determine that the risk is more moderate and we would be required to see them within 7 days. Within a 12-hour response, often we are working alongside police. There are regulations under our Act to do joint investigations. Where I have seen some of the challenges is really around getting data to actually address and to find where a child may be, especially if we're looking for a missing child or maybe in an Amber Alert. We have had situations where it's been difficult or the police are waiting to get an order, and then they're not able to do that quickly enough.
Thank you. I apologize for cutting you off, but we do have to move on to Mr. Ramsey for 6 minutes, please.
Ma question s'adresserait à M. Pierce.
My question is for Mr. Pierce. Mr. Pierce, you heard, in fact, as it happens, you're on a panel with 2 people who deal with cyber crimes. And you've heard that sometimes an accused could have 92 victims between the ages of 9 and 12 or 13, 200 reports per year. Obviously, the police authorities need powers to be effective. And at this point here, the current system is not working. It takes months. So how do you reconcile that with the needs out there? We're talking about child pornography online or sextortion or extortion, which can affect businesses. Recently, Surrey, Brampton are dealing with repeat offenses, repeated crimes, and information has to be provided completely and quickly. And how can all that happen right now?
Well, thank you very much for the question. I guess I would start first from a cybersecurity perspective, that I don't think it makes anybody safer if our systems are compromised. And so that's a fundamental point. All of your data, all of my data, all of our family's data, financials, pictures, whatever the case may be, your location data to indicate when you're home or you're not, so your house can be broken into. All of this data, our whole world is digital. And if we lose the encryption of these major systems, that is a fundamental risk to the Canadian economy. That's a fundamental risk to businesses doing business successfully in our country. And it would put us out of step internationally with countries where large providers who provide these services, their systems would be at risk. From a business perspective, I think it's critical to remember the context that we're in right now. These are not smooth economic times. And you're talking, in the case of a large provider, adding to their balance sheet millions of dollars of additional expenses. But what about the smaller providers, the smaller businesses, the smaller electronic service providers across the country that fill gaps that the large do not? They don't have the capacity to pivot and turn and finance large operations to support law enforcement essentially being able to come in and attach a device to the back of their system and work there with them over a long period of time to facilitate it. I just go back to my opening comment, though, if I can. We all want law enforcement to have tools that are effective. We all want law enforcement to be able to pursue the criminals, to protect our kids, to protect our families, and all of us. It's really important that the balance between the measures that this bill provides are balanced with the protections for our data and our privacy, and of all else, protect our encrypted systems.
All right, but the law, le projet de loi prévoit également qu'il y a des...
Under the bill, there would be a prohibition
against electronic service provider implementing a capability that would introduce a systemic vulnerability. Somehow you don't feel this is enough?
Well, I'll give you an example. I watched the testimony on Tuesday, and some of the officials, I forget who it was, but one of the officials made a comment that, in many of these systems, there are two keys, and so we can just have the providers issue a third key or another key that we can use. Cybersecurity is not just technology. Cybersecurity is equal parts technology and humans. The human interaction with technology, I'm sure everybody knows someone who opened an email that let some virus into your system. And so the question is, who's managing those keys? Who's protecting those keys? How are those keys protected? Who has access to them? Keys change. Who's updating those keys? Who's doing the patches on those systems? Look at FinTrack. Look at some of these large Salt Typhoon hacks where these are very sophisticated actors. It's funny, and I go back to my opening comment where I expressed a bit of frustration just because cybersecurity is looked at differently from every other crime. Cybersecurity and the real hackers of today are not in your basement in one of our major cities. They're foreign adversaries. They're state sponsored. And these are sophisticated operations that if you just add a new door to the back of a system, they will have been there on Monday. The door appears on Tuesday. They're going to say, that looks different. It doesn't look like the other doors. And so they'll start to probe it. And that immediately becomes a target. And again, I go back to the point about the whole concern from the business community is one, on encryption and making sure these systems are protected. But two, it's about ensuring we have the ability to conduct commerce that we can have trust that our systems are safe, that our information is safe. And if the measures of C22 Part 2 are implemented as written, the language does not preclude the concerns I've just outlined.
Madame de Bellefeuille, vous avez 6 minutes.
Madame de Bellefeuille, you have 6 minutes. Thank you very much, Mr. Chairman. My question is for the Chamber of Commerce. In a time where American tariffs are making life very difficult and uncertain for our businesses, do you feel that if we don't clearly know who will be subject to C22, will that make the future even more uncertain, and will this undermine business?
Absolutely. And I'll share quite honestly the discussion in industry when this law was first introduced. Many thought they were excluded just simply by the fact that they weren't defined as an electronic service provider. But when you really look into that definition, it's providing an electronic service. What do you use today that doesn't use some form of electronic communication? My car does that. We've got so many different devices and pieces of equipment. It's not typical, just narrow casted to one small subset with the language that's in the law. Our suggestion is that there be a primary function test applied to the definition of a core provider that narrows it down to companies that are specifically in the business of communication, which is ultimately what I believe law enforcement is after. But if left as is right now, as we were going through this with our members across the country, initially industries thought they were excluded, and then they went back and looked at it and said, well, geez, you're right, this could capture us. And so that ambiguity really should be closed in this process, we hope.
Du Québec, I'm a member, or rather, MPs from Quebec and across Canada want to support C22, but and we feel, or rather we hope, that this bill will be adopted and improved. So do you feel that the steps you will need to take to prepare for requirements under C22 are huge? Will this cost a lot of money to your members? Will this have an economic impact on your numbers? Have you assessed how much this could potentially cost your members?
Thank you for the question. So on the cost piece, and then I'll work backwards from there. Large providers in the millions to set up the infrastructure to comply with this, and then millions more in operational cost. It's very important to remember, metadata is not something you can just go in and read. It's got to be in a usable format that law enforcement would find useful and helpful. The bill is in two parts. I think, I believe the clerk will be distributing an English and French letter from the Chamber of Commerce to members where we've identified areas that we think both Part 1 and Part 2 need to be improved. But we understand the Spencer decision. And really, I think Part 1, with the changes that were made, with the changes we've recommended in our letter, perhaps there's an opportunity to split the bill so that Part 1 can move forward and achieve some of the concerns that I know the first two speakers, or my other two colleagues on the panel, spoke to so eloquently earlier. And we can study Part 2 a little bit more, because from my perspective, when you look at the authorities in 5, 7, 14, and 20, and the number of lawyers I've talked to over the past year where they cannot rule out whether or not a warrant is required or not, to me says this might need some more study, it might need some more work, and I would hate for it to be passed in order to resolve what Part 1's after, and then create a host of trade and business issues for the economy as well.
Tout de suite, vous savez, si le gouvernement avait...
If we had a majority of government, C2 would have been adopted. But the government did its homework again, consulted again. Now we have C22. Now, I don't feel very positive about your suggestion that the bill be split in two. So could you send us very specific amendments which would help mitigate the impact of C22 on businesses and help them to transition and to abide by the requirements of C22. You said you've consulted your members, so would you have very specific suggestions to make to improve this bill?
Thought you would never ask. Absolutely. We would be happy to submit amendments to correct the legislation to address the concerns that I've outlined. And in particular, you'll find in the letter that will be distributed, I presume by the clerk at some point, that at the back of the letter, we've identified issue by issue for part 1, part 2, and then for both parts of the bill. And that would obviously be what we would use as a guide to develop those recommendations. Thank you for the offer.
Juste pour vous spécifier.
Just to be more specific, the study for this, rather, the timelines are fairly tight for the study of this bill, and we will have to send in our amendments by May 27th. So I'm just letting you know that any suggestion to improve the bill will be welcome, and I would like to thank you for speaking on behalf of businesses. We've heard from many witnesses, and we appreciate your input on how to improve this bill. Thank you very much. Thank you, Madame de Bellefeuille.
Benefit of the committee, we have been running a little bit late, not because we have not been efficient, but because we have had more opening statements than we are used to. So what I would propose to do to ensure that we give our next panel the appropriate amount of time is to now have a 4-minute round from the Conservative Party and a 4-minute round to the Liberal Party, and then move on to the next panel so that we can finish on time. Hope that is okay. All right, we will move to Mr. Lloyd for 4 minutes, please.
Good. Thank you to the witnesses. Hello, Mr. Pierce. It's been a while. Good to see you.
Hello, sir.
I was wondering if your stakeholders in the business community would be satisfied with a more specific definition of the term systemic risk, and would that allay some of the concerns?
Very much. And I think, especially listening to the testimony on Tuesday, the key here is that the legislation specified that it's not just about creating a systemic vulnerability, that service providers will not be required to break encryption. And that's a very important principle that is assumed with the current definition, but we believe should be very clearly codified in law to address the concerns of industry.
And Dr. West was talking about how these powers should be administered by the businesses and the operators themselves, not by law enforcement. Is that your understanding, that that would be preferential?
I would go back to my comment in the opening statement. I believe the business community is fully behind exigent circumstance, quick turnaround production orders. They know their systems, they know where the data is, they know how to pull it and produce it in a way that can be useful, and not at the same time create that vulnerability that I think we've been so clear about.
Yeah, I think, one concern I have is, like, if law enforcement comes to, one of your stakeholders, an operator, and says, we need access to this system, your company, the companies are going to ask for a warrant or a ministerial order. But if law enforcement is given the capabilities through a ministerial order to have direct access to the systems, what safeguards are there to ensure that maybe some bad actors aren't using that access? We've seen in some cases there's allegations of, people in law enforcement looking up, ex-spouses and things like that. What guarantees can we add to this legislation to ensure that that some bad actors aren't going to use this trove of new data in an abusive way?
Well, bad actors and corporate espionage, competitors. The intellectual property of these companies is incredibly valuable. And to just give unfettered access for someone to peruse around as they see fit is a great risk. Our biggest focus is that, as I mentioned previously, we believe production orders are the way to go. That is the most clear option. Sorry, go ahead.
Integrated childhood exploitation centers were telling me about how many of their child exploitation investigations were shut down because they rely on tips primarily from the FBI. Does this legislation fix the problems created by the Biovics 5-4 decision? Saint Germain?
I didn't hear the first part of your question. There was no sound coming through.
Oh, sorry. The Biovitz Saint Germain decision, I was told by the Integrated Childhood Exploitation Centers that many of their tips come from the FBI. And were they shut down because of the Biovitz decision? Does this legislation fix that issue?
I mean, it helps at Part 1 because it has the provisions about voluntary provision of information and clarifying that police can use information that is voluntarily provided, which is a lot of what the tips that are coming from the National Center for Missing and Exploited Children in the U.S. are. Those are coming through and then they're being sent over to our police forces. And in some jurisdictions, there's some uncertainty as to whether or not the police can actually use that information to then start the investigation. So the parts in Part 1 that are talking about the for greater certainty provision and the clarification about voluntary information, yes, that will help.
I'm sorry, Ms. St. Germain. Oh, thank you. That was great to come to a natural end. Ms. Akan, for the final 4 minutes, please. Thank you.
Thank you very much, Mr. Chair. I will go with Mr. Pierce with my first question. So the open letter that we received raises some concerns that the orders could be used to obtain sensitive medical or financial records. Can you acknowledge for the committee that, or explain for the committee that the section 487.021.3 of the bill creates an explicit prohibition against making any demand that would disclose medical information or solicitor client privilege?
Sorry, this is with regards to Part 1 or Part 2?
This is Part 2.
I apologize. I'm not familiar with that specific section, so I'd like to, if I could come back to you with that afterwards, that'd be great.
Okay, no worries. So I will continue my questions with C3P and the PLCAS. I have volunteered countless hours over many years supporting organizations like SEVIS of Halton, and SEVIS serves as a leading agency in my region, in Oakville, also, and backbone organization for the Halton Collaboration Against Human Trafficking, and bringing community organizations partners to create coordinated regional response to combat human trafficking. It's an organization such as yours. So organizations like yours play a critical role in protecting vulnerable individuals and strengthening community awareness and prevention efforts. Unfortunately, traffickers have frequently used Oakville and Burlington as a transit hubs because of their proximity to major highways and moving victims between hotels along these corridors in an effort to avoid detection. We are fortunate to have the dedicated members of our Halton Regional Police Services, and I want to sincerely acknowledge and thank them for their continued work in combating these horrific crimes. So over the past year, I have spoken with many officials from different levels of law enforcement, and they have consistently emphasized that the child exploitation investigations are extremely complex and time-intensive, and these cases can often take more than 6 months to resolve, particularly due to criminals use phones, computers, cloud services, and storage devices to conceal illicit material. From your perspective, how would Bill C-22 improve law enforcement's ability to investigate and combat child exploitation and human trafficking offenses?
Bill C-22 will help law enforcement to be able to access this information quicker. And we sometimes have minutes, hours, when we're speaking, when we're looking at an investigation and trying to protect a child. I want to speak a little bit from the Pearson Airport perspective. Sometimes we have children and youth that are coming through the airport that have been identified, and being able to access that information and really look at that digital footprint is important, because once they go through, we may have no other opportunity to see that child again and may not know where they end up. And you rightfully said, within the GTA, there are many different transportation routes from the highways to the airports, and this creates some challenges. So that access to doing that quickly is extremely important, because time is of the essence in those cases.
Thank you very much. Madame Saint-Germain, do you want to add anything to that?
Yeah, what I will say is that particularly the provisions of Part 1 will be very helpful because a lot of the child sexual exploitation investigations that involve either a tip from a provider through NECMEC or something like that will just be a very minimal amount of information. And police can't really do a lot with that information until they can sort of get a little bit more information. So
Thank you,
the
Ms.
information
St.
demand
Germain. I apologize. I have to cut you off. I'm really sorry. We are running late.
Okay.
Here. I encourage all of the witnesses, if they wish to provide supplemental information to the committee. You all play a critical role. And on behalf of the committee, on behalf of all Canadians, we are grateful for your work, so thank you very much. We will suspend for as short a time as possible, preferably 90 seconds. Thank you. Sorry, I apologize if that was a little bit aggressive. want to thank, we have all the panels today have been excellent. We have a very distinguished panel here that I really don't want to lose any time with. I want to introduce from Meta Platforms, Inc., Rachel Curran and Robin Green. From NCIRA, we have the Honorable Marie Deschamps and Craig Forchese, as well as Lawrence Mangiano. I don't know if I pronounced them right. Okay, they are Italian names, so I have to pronounce them the right way, I hope. And finally, the Honorable Simone Noel and Justin Dubois. We will now have opening statements. I have to vacate the chair for about 3 minutes, so if anything comes up, Madame de Belfay will deal with it. And I will hopefully be back in 3 or 4 minutes. If I'm not, please just go on to the next opening statement. So we will start with the opening statement from Meta, please. Thank you.
Thank you, Mr. Chair. Good evening, and thank you for the opportunity to appear before the committee today. My name is Rachel Curran. I'm Head of Public Policy for Canada at Meta. Joining me is my colleague, Robin Green, who is an expert in the subject matter under consideration, so please direct your technical questions to her. Listen, Meta is deeply committed to keeping our Canadian users safe online and offline. We routinely engage with Canadian law enforcement agencies at all levels of government, including by proactively reporting threats we identify or responding to valid legal demands and emergency requests from Canadian authorities. We commend the government for addressing many of the concerns that were raised about Part 14 of the previous Bill C-2. With narrowly tailored amendments, we think the current Part 1 of Bill C-22 would provide law enforcement with an effective legal framework for obtaining the necessary data in a timely manner. However, Part 2 is a different story and could ultimately make Canadians less safe, not more. First, the technical assistance obligations in Part 2 could conscript private companies into service as an arm of the government's surveillance apparatus. As drafted, the bill could require companies like Meta to build or maintain capabilities that break or undermine encryption and force providers to install government spyware directly on their systems. The bill purports to protect against risks to encryption by allowing providers to challenge demands that would introduce a, quote, systemic vulnerability. However, the definition of systemic vulnerability is unclear. Essential terms like encryption are left to be defined in regulation, while ministerial orders can override those same regulations. Moreover, the bill contains no process for challenging a problematic order or liability protections for companies while a challenge is pending. The technical community's consensus on this is clear. It is not possible to build backdoors to encrypted systems for law enforcement without creating vulnerabilities that will be, not if, will be exploited by malicious actors. Weakening encryption does not just affect the target of an investigation, it affects every Canadian who depends on secure private communications to bank, access healthcare, run a business, or simply talk to their family. And this is not a hypothetical risk. Governments around the world are still dealing with the fallout from China's state-sponsored Salt Typhoon cyber attacks, which exploited the U.S.'s far narrower technical assistance laws. Canada's own security agencies understand this, issuing guidance that specifically advised adopting encryption to defend against these kinds of cyber attacks. Part 2 of Bill C-22 would move Canada in the opposite direction and out of step with our closest allies. Last year, France and Sweden both abandoned similar proposals, and the EU guaranteed robust encryption protections in its agreement on online safety. The UK's use of a similar authority, ordering Apple to break its encrypted cloud service, drew condemnation from the US government and 200 global civil society organizations, and ultimately resulted in Apple withdrawing its advanced data protection service. Imposing these obligations would also chill domestic innovation and investment and harm Canadian competitiveness abroad. In addition, Part 2's overly broad non-disclosure orders risk undermining public trust and transparency. The bill's data retention provisions create a framework to capture the private information of ordinary Canadians with no connection to any crime. And they also grant warrantless authority to search company premises and seize data. In light of these significant challenges, we urge policymakers to separate Part 2 from Bill C-22 so that these critically important issues receive the time and attention they deserve. To avoid the worst privacy and security outcomes, required changes include removing obligations from companies to add government or third-party surveillance tools or software to their systems, strengthening the definition of systemic vulnerability to explicitly rule out any requirement that would weaken or break encryption, and codify the process for companies to challenge requests.
I have to be
Thank you,
ruthless
Mr.
with the
Chair.
time. Thank you.
Thank you.
Next, we have the Honourable Madame Deschamps pour 5 minutes, s'il vous plaît.
Monsieur le Président, membres du comité, bonsoir.
Good evening, Mr. Chair and members of the committee. Thank you for inviting us to participate in your work. I am the chair of the National Security and Intelligence Review Agency, or NCIRA. I'm joined by our vice chair, Mr. Craig Forsisi, and our Secretariat Acting Executive Director, Mr. Lawrence Mangano, which you pronounced Italian style a little earlier.
Points. Given the scope of new powers in this bill, timely and effective independent review is essential. C'est mon premier point. Le deuxième, this bill,
the second point,
falls short of supporting that review. L'Office s'acquitte principalement de deux fonctions.
NCIRA has two core responsibilities: review national security and intelligence activities to assess whether they are lawful, reasonable, and necessary, not to confuse with previous authorization or prior authorization, which my colleague here, Mr. Noel, does, and which he will speak to a little later on. The second core responsibility is to investigate public complaints related to national security and intelligence.
So, we provide independent assurance to Canadians that those activities comply with the law, including with the Charter. Bill C-22 introduces significant new powers through the proposed Supporting Authorized Access to Information Act. Given the breadth of these new powers, NCIRA anticipated a review role that would provide timely and direct visibility into how these authorities are used. Toutefois, dans sa forme actuelle,
however, as drafted, Bill C-22 provides NCIRA with the Minister's annual report only. In practice, this could mean delays of more than a year before NCIRA becomes aware of how these authorities are used.
NCIRA has broad access rights. There is a real benefit in legislation that requires information to be provided proactively to NCIRA in a timely manner. In the context of constrained resources, early awareness would provide a meaningful baseline of what activities are taking place and allow NCIRA to plan and target its reviews more efficiently. Nous accueillons favorablement
We do welcome the requirement for the Intelligence Commissioner to receive approval of ministerial orders. However, the absence of provisions granting ESCIRA access to those orders or information about how they are implemented limits our ability to assess their use in practice.
Pour répondre à ces problèmes,
to address this, we recommend two targeted amendments.
Amend Section 9 to ensure ENSIRA is proactively provided access to classified ministerial orders issued to service providers, as well as to information provided to the Intelligence Commissioner in support of those orders. Second, amend Section 27 to ensure ENSIRA is informed when compliance orders are issued, including information relevant to potential non-compliance. These changes would enable more timely, targeted, and effective reviews. De plus, ces modifications sont cohérentes.
They are consistent with existing Canadian legislation where ENSIRA receives proactive information related to activities conducted under ministerial authorization and with recognized international practices. Similar provisions are found in Australian law. Feel free to ask me questions about that.
Stone of public trust in Canada's national security framework, ensuring that ENSIRA has timely access to relevant information will strengthen accountability and support Parliament's intent in establishing these authorities. Je vous remercie de votre attention. Nous sommes disposés à répondre à vos questions.
Madame Deschamps was on the Supreme Court of Canada when I was a law student. I just can't cut her off. Monsieur Noël, pour 5 minutes.
Lumière rouge. There's no red light.
Ah oui, c'est ça. Il n'y a pas les lumières rouges pour les plaideurs.
Right, there are no red lights for them.
Merci. Merci, Monsieur le Président.
Thank you, Mr. Chairman, and members of the committee, thank you for this invitation. I am accompanied today by Justin Dubois, Executive Director and General Counsel at my office. Bill C-22 gives my office a new and significant function. I want to explain how this function would fit into my existing duties.
Function as Intelligence Commissioner, or IC, is to approve or not approve certain national security and intelligence activities proposed by CSC and CSIS and authorized respectively by the Minister of National Defense and the Minister of Public Safety. My independent approval is necessary because the activities of the ministers that the minister authorized may be contrary to the law or breach the reasonable expectation of privacy of all Canadians. I have 30 days to render my decisions, but adapt to much shorter timelines when urgency calls for it. Only with my approval can the activities be conducted. When I approve a ministerial authorization, I assess whether the minister's conclusions are reasonable in light of the factors the legislation requires the minister to consider, including the impact on privacy interests and cyber security. For most of my decision, my primary concern is how the proposed activities impact the privacy of Canadians. I apply the legal principles of proportionality and reasonableness and ensure the compliance with the Charter, including Section 1. À cet égard, lorsque j'examine les
In this regard, when I look at the factors the minister must consider when issuing an order under this bill, I'm confident that these orders are similar, more or less, to the ministerial decisions I currently oversee and raise legal issues my office is well versed in. In my experience as commissioner, I understand how certain orders can only be effective if they remain confidential. Although I operate in a classified environment, My oversight role calls for me to be as transparent as possible with Canadians. I share my decisions with NCIRA, of which Mr. Deschamps is in charge of, for post facto review purposes. I publish redacted versions of my decisions on my office's website. Decisions rendered under this bill would likewise be published. My annual report, which was tabled in Parliament last week, additionally provides information on the impact of the activities that I oversee and the important issues of law that are in play.
Additional resources for this new function. I have no control over the number of ministerial orders that I would review, nor how complex or voluminous each file might be. Another consideration is the potential effect of judicial reviews. These considerations could impact the resources my office needs. My role is on a part-time basis, and I adapt my work and my life accordingly. My expectation is that that if my office requires additional funding, this will be provided in a timely manner. I would certainly appreciate a firm commitment from the Minister to that effect. One element I would raise for your consideration relates to the Minister's extending or not the validity period of an order. Currently, there's no limit to the validity period or the length of any extension. Under my existing jurisdiction, maximum validity periods are specified and renewals require a new approval by the IC. I suggest a similar approach in this bill. Je serai heureux de répondre.
I would now be pleased to answer your questions.
Merci beaucoup.
Thank you very much.
Running a little bit late, so I would propose to, at least for this round, go to 5 minutes a round. I hope that's okay, because I don't want anybody to lose their round. So with that, we will begin with Mr. Lloyd for 5 minutes, please.
Thank you, and thank you to the witnesses for being here. Madame Deschamps, were you consulted in the drafting of this legislation?
I understand that this question has been posed to the Minister. I have been meeting with the Minister according to the statute once a year, and when we met in December for our yearly meeting, Bill C-22 did not come up.
Okay. I think philosophically, one of the reasons why Canada is such a great country is precisely because of the accountability that we have, redundant levels of accountability. And that's why I'm quite shocked that, this is the second iteration of this legislation. We had C2, now we have C-22. And basic accountability things like you talked about, review capabilities, were not included. And I'm highly frustrated given the seriousness of the issues that this legislation seeks to address, child sexual exploitation, and yet basic accountability measures like review are not being included. Could you maybe talk about the importance of why NCIRA should be involved in the review process?
At NCIRA, we regularly receive information about authorizations, and we don't just ignore them. We integrate them into the bulk of our knowledge about the operations that the agencies are conducting, and that with that knowledge, we are building the amount of information that we need in order to plan our activities and also in order to get to a better understanding of how the agencies are operating. So it's very important that we get these, specifically for this bill, that we get the information as early as possible. And that moment in time would be the minute the Intelligence Commissioner issues his approval.
Thank you, and I sincerely hope that we can get some amendments like you proposed discussed here more fulsomely. I'm just very frustrated that this wasn't included in the legislation by the Minister of Public Safety in the first hand. Ms. Curran, I brought it up in another witness that does Meta advertise its privacy controls to its consumers?
We do. Yeah, we have a transparency center that outlines all of our privacy policies. We implement essentially privacy by design into all of our products, and we make that very clear to all of our users what our policies are.
So if you were to receive a secret ministerial order to install a device or create a capability for law enforcement to circumvent those advertised privacy controls, how would you be able to tell your users that those things that you're advertising are no longer allowable?
We wouldn't, and this is a major issue. I'm going to let my colleague Robin go into this in more detail because this is an important question.
Yeah, thank you so much for putting this question forward. Ultimately, as drafted, the bill has a blanket secrecy provision that would essentially prevent us from being able to explain to our users that these changes had been made, or if discovered, why they had been made. And I think this latter part is really important because ultimately our services are available around the world, and that means that there are security researchers and technical experts and journalists around the world who regularly decompile and reverse engineer our products. Sometimes it's because they're trying to look for vulnerabilities and help us shore up our systems through like bug bounty programs. Sometimes it's because they're trying to see if they can get any information on what our next, product and feature releases are going to be. This happens for all companies like ours. And so ultimately, these kinds of changes will be discovered. It's not a question of if, it's sort of, as Rachel was saying, just like the exploitation of a vulnerability would be a question of when, the discoverability of this would also be a question of when. And then providers are in a really significant conflict because our users would completely lose trust in the security and privacy protections of our products.
Sorry to cut you off, I have limited time. Apple threatened to leave the United Kingdom because of their laws. Do you foresee major companies also possibly having to leave Canada because of this legislation if it goes unamended?
I can't speak to what other companies will do, but I think that there are a number of companies that have gone on record stating clearly that they're not open.
Thank you very much. I'm sorry that I do have to cut you off there. Next, we have Mr. Zuberi for 5 minutes, please.
Merci à les témoins d'être ici and of us today. And a lot of respect for the work that you have done throughout your careers. I would start with you, Monsieur Noel, Justice Noel. And I have come across your work over the years with respect to security certificates and many other pieces of national security legislation, and have a lot of respect for this. With regard to what you stated earlier, that one of your key functions involves privacy, looking at privacy with respect to this legislation. Would you suggest that it would be at all helpful for the Privacy Commissioner to be involved in this legislation and this process?
I think not knowing exactly what is in the privacy law, I think already he is following the work I'm doing through his personnel, and I think he would be doing the same if it was the case. The distinction to be made between the Privacy Commissioner and myself, I'm involved in the decision-making process. The Privacy Commissioner is not involved in any government decision.
I understand. And currently, Canadians have a reasonable expectation of privacy. And this legislation will shift that landscape. Can you explain how it would shift that landscape, and can Canadians still expect a reasonable expectation of privacy given the scope of this legislation?
Well, it's hard to guess what will be in the future. With the new era we're in, gone are the days of the telephone book, where the police organization could go and consult. The meta groups and all the others, they control all that information. The government is put in a position of trying to improve the system of investigation across Canada. In doing so, it is trying to set up a framework, une architecture pour pouvoir le faire. I would suggest to you, sir, that Canadians when they hear about pedophile issues, bank frauds, expect the system to adapt to the new era, and measures have to be undertaken. This is one proposal. Some people don't like Chapter 2, but somebody at one point will have to decide how the data banks essential to the police organizations will be used, and that's one example.
I know you've spoken about the duty of candor by CSIS and other agencies. I understand your current role is different from your role in the past, but Madame Deschamps or Mr. Noel, if you have any comments about potential concerns around duty of candor or not just that actually, compliance by policing organizations, those that have the authorities, do you foresee any potential concerns?
My experience, my past experience, as you have noted, shown that I had to call it as it is, a breach of duty of candor. In the present position I'm in, I have put the burden on both agencies to tell me, to brief me on everything that they're going to present to me. Because if they don't tell me exactly what I should know or not know, they will pay for it because the decision will not be granted.
I'll use the remainder of my time to plead to Meta to please do curate an environment online that is, family-friendly, not just family-friendly, to be honest, one that invites people to positively participate as an elected. We have so many comments on our social media that are, do not create environments that encourage positive discussion. So just want to put that out there to you. Thank you.
Thank you, Ms. Zuberi. Mr. Zuberi, you are out of time. Prochaine, Madame de Bellefeuille.
Next, Madame de Bellefeuille for 5 minutes. Thank you very much, Mr. Chair. I'm very happy to hear you all. We've been here for nearly 4 hours, and you're the only francophones who've spoken French in 4 hours, and that's good for me. So, Madame Deschamps, you had a youngish organization. It's about 6 years old, and I have the impression that I'm the MP who would like you to be better known by all of us here. Now, in listening to you, I'm being made aware of how important your office is in terms of protection and monitoring. Now, in this bill, the minister, who also doesn't seem to understand what you're asking for and what I will ask for, is that you be notified. You're not involved in decision-making. We understand that. So can you explain to us how in Australia or in other countries, agencies such as yours have chosen to add more monitoring of the information? Well, thank you for asking that specific question, because when I was listening to the testimony, I got the impression that there was confusion between my office and that of the Office of the Intelligence Commissioner. The Intelligence Commissioner gives prior approval to a minister or to activities, and afterwards the agencies do the work. And then we are the ones who look at governance, but mainly what we look at is whether the actions are legal, reasonable, and whether the powers are applied only when necessary. So we examine activities after the fact. I'm sorry, I don't want to interrupt you, Madame Deschamps. I only have 5 minutes, and we understood that point in your opening statement. What I'd like you to explain is that in other countries, they've chosen a different way of doing things. Agencies in other countries are notified in real time, for instance, by an intelligence commissioner. Explain to us why that would be an advantage to Canadians and Quebecers. That is, that your office be informed in real time. Because to find out a year after something has happened, well, that would require more investigative resources, which you might not necessarily have. You might not have the resources to quickly determine whether rules have been followed or not. Is that what you're saying? Yes. Well, in Australia, for instance, it's only a few days for their agency to be informed. And that way, surveillance agencies don't have to ask for the information. And that doesn't help anyone. It means that we have to go begging for information everywhere. It's very time-consuming for everyone. All we want is for the system to be more effective. If we get the information automatically, it makes the system more efficient. In his testimony, the minister said that he would not agree with that approach, and this is what I understood, that it would slow down the process. But I don't believe that, because most of the work is carried out by the intelligence commissioner, who has a huge responsibility. But in your case, to know that you're there, you know what's happening, and you're following, if you're able to follow events, well, if you know there is a violation of process, well, then you can speak out. So, Ms. Deschamps, it seems obvious to me that Canadians and businesses today are worried. However, you would be an extra safeguard. Why should we not have that extra safeguard? Well, we would be there, but after the fact. And also, technology is evolving so quickly. So by the time we could put out a report, the technologies might have expired and new ones would have taken its place. We don't want to spend a lot of time getting the information. If we got it more quickly, it would be more efficient. And so we would be able to plan our work better, and we would be in a better position to look at the actions taken. The government looked at what the other Five Eyes countries are doing, but didn't adopt all the best practices. It looked at what Australia was doing. Thank you, Madame de Bellefeuille. And Madame Deschamps.
On to Ms. Kirkland, who I was supposed to recognize earlier. I apologize for that. You have 5 minutes, please.
That's all right. Thank you so much. One of my colleagues on the other side used his last 30 seconds to implore Meta to limit free speech, and I would like to use my first few seconds to implore Meta not to limit free speech. So I would say that first. Ms. Curran, you were rushed at the end of your testimony to sort of finish off, and I wanted to give you a minute, if you could, or half a minute to maybe repeat your conclusion so that we can really understand it.
Thank you, Ms. Kirkland. So we just have three recommendations on this bill. Remove obligations for companies to add government or third-party surveillance tools or other software to their systems. That includes our company. Strengthen the definition of systemic vulnerability to explicitly rule out any requirement that would weaken or break encryption, mandate client-side scanning, or otherwise introduce a security weakness. And 3, codify the process for companies to challenge problematic requests. I think we've heard after-the-fact protections are really no protection at all. So those are our recommendations to deal with Part 2. We actually think, for what it's worth, Part 1 responds to the criticisms that were made about Part 14 of the previous Bill C2. They provide a good framework, subject to a couple of tweaks, to provide law enforcement with the information it needs to conduct investigations. Part 2 is really the problem with this bill, and so we're recommending some pretty significant fundamental changes to that part.
Thank you very much. I just also wanted to give you a moment to respond to the Intelligence Commissioner's comments. And, you know, I do understand we are in a new era and things have changed in terms of what is available online and that sort of thing. The only comment I think you'd want to comment on is apparently you control all of this information, just like the phone book used to. Would you like to comment on that at all?
Yeah, I'll get my colleague Robin to weigh in on that. Yeah.
Thank you. Yes, I mean, we of course do not control all of the information. I think one of the things that's really critically important about the services that we offer is that people use our services for different things. And that is why we are proud to be one of the largest service provider of end-to-end encrypted communication services in the world. At the end of the day, people are extremely dependent on having secure and private mechanisms for having communications, whether that's with friends and family, running their businesses, engaging in day-to-day life. And the reality is that governments rely on end-to-end encryption as well to conduct government business and represent the interests of constituents. I think the idea that technology is changing so quickly is actually one of the most important things for us to think about, because when you think about encryption, that is actually one of the technologies that is changing very quickly, but not in the way that many people expect. One of the new sort of waves of development in encryption technology is the implementation of post-quantum cryptography. One of the greatest threats that we're facing today over the course of the next several years is, as we see advances in quantum computing, there need to be similar advances in post-quantum cryptography, because that's the only type of cryptography that's going to be resistant to the, ability to decrypt previously encrypted information. One of the things that we're concerned about with this bill is that there aren't sufficient safeguards to ensure that encryption won't be undermined, or a mandate to break encryption won't be imposed. And that becomes significantly more dangerous in the future when you're looking at trying to build secure exceptional access, which is really a paradox in itself. It's not something that's possible to do, but it's even much more difficult in the future state of post-quantum cryptography.
So much to unpack there. There isn't time to do it here. I wish I could have you here for another hour. I'll ask these simple, they're really just yes-no questions in this one. And I think you've said it already. Would compliance with Bill C-22 introduce new systematic cybersecurity risks for global platforms operating in Canada, particularly where they are required to retain or produce metadata or subscriber information at scale?
As currently drafted, yes, it could.
You said vulnerabilities will be exploited. Is there anything at all in this bill that protects against this exploitation to protect Canadians?
There's nothing sufficient. Right now, the provision around making sure that providers don't have to comply with an obligation that would introduce a systemic vulnerability does not offer sufficient process or enough scope and clarity of definition to be sure that we wouldn't literally have to introduce the systemic vulnerability that the bill is purporting to prevent.
All right, thank you.
Thank you very much. Thank you, Ms. Kirkland. And now we go on to Mr. Housefather, please, for 5 minutes.
Thank you, Mr. Chair. I'll try not to geek out about a Supreme Court justice being here, but it's also something that is very exciting. Yeah, of course. Maître Deschamps, je vais juste commencer avec vous. Je crois que...
Ms. Deschamps, begin with you. I believe you've already explained clearly what you are here to say. You sent a minister to the committee chair, Jean-Yves Duclos, on April 16th with 2 proposed amendments. If those 2 amendments are adopted by the committee, and if they eventually are included in the bill, would that be enough for you to mitigate the concerns of your organization? In a word, yes. And thank you also, Mr. Simon, for being here. I have a question for you. You talked about the necessity of having additional resources. Well, that's clear. You have a very important mandate under this bill. So do you feel there are any changes we should make? I understand this is not quite your role, and if you tell me you don't have an answer to that. However, Do you have any suggestions to improve the bill apart from the fact that you may need more resources? The only thing I would say is that at section 7.3, I would add that the decision must be taken on the basis of proportionality and reasonableness. To exclude paragraph A must be balanced with
order on the persons to whom the electronic service provider provides for, and the potential impact of the order on privacy protection and cyber. Il faut qu'il y ait une mise en balance entre les deux. C'est pour ça que
the bill needs to strike a balance between the two, proportionality and reasonableness. Can you perhaps send that in writing? Thank you.
Thank you, by the way, for coming all the way from D.C. Very much appreciated. Rachel, I know you didn't come quite as far, but thank you also for being here. My question to you, I don't think it's feasible that we're just going to drop Part 2, but I do understand the requirement. One thing that I'm very sympathetic to is the question of the clarity. First of all, of a clear definition of a systemic vulnerability, and number two, a clarity that the order, should such an order be given, is still subject to that an order can't require you to do something that creates a systemic vulnerability. Would that largely assuage some of the concerns that you have?
Yeah, look, I think if you clearly defined protection of encryption in the bill, that would go a long way.
That end-to-end encryption is not, nobody's going to ask for an end-to-end encryption to be broken.
Exactly, and I know the government has said their intent is not to break or weaken encryption. If that's the case, make that clear in the bill. And I think also if you included in the bill a provision that prevented the government from making a request that it reasonably believed would create a systemic vulnerability. Right now, the onus is all on companies. It's all on us to challenge a request and say that it will create a systemic vulnerability, and the process for doing that is not entirely clear. But I think if there was some onus on the government not to make requests that they believed would create a systemic vulnerability, that would also go a long way towards assuaging these concerns.
Thank you. Do I have any time? Oh, do I have any time left, Mr. Chair? Or?
Have 1 minute and 10 seconds.
Okay. Just wanted to also note that, of course, a lot has come up about the terms and conditions of Meta. I would say that having read the extremely long terms and conditions, it would be very easy to put in a caveat to say that one of the many exceptions to the privacy, that you're guaranteeing the user would be the Canadian law should in the event that X and X happen. But let me just come back. Since we have an expert from the States, can you just talk to us about the major differences between the two major pieces of U.S. law and this one, and where you see the distinctions?
Yeah, so under U.S. law, the Communications Assistance for Law Enforcement Act is the governing authority where specifically telecommunications providers and ISPs are subject to obligations to make sure that their services can be intercepted, essentially, in response to Wiretap Act warrants. There are very clear exceptions for over-the-top services, such as the services Meta offers and other apps. So we are not subject to the same requirements. In addition to that, there are protections for encryption explicitly in that law. The All Writs Act is also not really a clear path and has never been established in court as a mechanism for successfully mandating an encryption backdoor. The last point I would make is that it was the very provisions of CALEA that led to the vulnerabilities that resulted in the Salt Typhoon and Volt Typhoon attacks.
Thank you very much, Mr. Housefather. And now, Madame de Belfait pour 2 minutes et demie.
Merci beaucoup. Thank you very much, Mr. Chairman. Mr. Commissioner, in another legislative context, you developed a practice of collaboration with the Office of the Intelligence Commissioner. Your two offices work together. Yes, we complement each other. So if ever the government agreed to the amendments which have been proposed, it would not mean extra work for you. You would simply keep on doing what you've been doing so far. No, I won't. When a decision is made, well, Madame de Bellefeuille, they're automatically sent to Mrs. Deschamps' office. Now, I understand I don't want to speak for Ms. Deschamps. I just make a decision. However, there are other documents and files that have to follow, and we don't have the control over that. I read the highlights of your last report, Mr. Noel. You rendered 14 decisions in the last year, a record, and I asked officials whether they evaluated with you the new role you might have, whether your workload would increase. The answer was, well, we talked and things should be okay. However, from the outset, you said, we'll have to adjust because we don't know what would be coming down the pipe. But given your experience, would you know what to expect for your office in terms of additional pressure? Well, it's really hard to know. I'm sorry, I didn't hear.
Bellefeuille has the floor. I'm just pausing time here. Go ahead, Madame de Bellefeuille. Thank you.
I work part-time. What does that mean? Well, let me explain that to you. If I compare my job to that of a judge, if a judge works 100% of the time, I work between 40 and 42% of the time. I still have some extra time. I have a margin, if you will. So I don't see that there would be a problem. However, we will see how files are sent over to me, and that's why I'd like to have a clear commitment. So it wouldn't be difficult to have to ask for resources. No, I don't want to have to beg Mr. Sabia for additional resources. That's right. I have an independence. I do not want to lose that independence, and I don't want to have to beg for additional resources if I need them. Thank you for your response. Mr. Noel.
Mr. Baber for 5 minutes, please.
Thank you very much, Chair. Welcome, Justice Noel. And before Madame Deschamps, just like my colleagues, I started law school in the same year as you were appointed Supreme Court Justice, and it's truly an honor for you to appear before our committee. Justice Noel, I understand the function of the Commissioner of Intelligence to essentially approve or not approve certain intelligence and other security activities. Is that correct?
Yes.
Okay. And I've also heard some of your remarks earlier to my colleagues. Have you had a chance to review the bill?
I glanced at it, and I looked more precisely what the role was expected.
Do you understand that you will be expected to sign off on orders made by the Minister of Public Safety to essentially install surveillance systems on private business? Do you understand that?
I fully understand.
Okay.
And
so
it's not something new to me. I'm aware of lots of things.
I appreciate that.
Which I cannot define.
What is important to me at this stage is who might be subject to that. So if I could just take you, I asked the clerk to give you a copy of the bill.
Yes, I got it.
If you could please look at page 37. So I'll take you there very, very quickly.
Yes, I'm...
At page 37, an electronic service provider, top left, a person that individually or part as a group provides electronic service in Canada or carries part of his business in Canada. So then the question becomes, what is an electronic service? And that is at the prior page. If you go a page earlier, electronic service means a service or a feature of a service that involves creation, recording, storage, processing, transmitting, reception, or making available information in electronic form or other technological means. So that sounds to me like a law firm that has a server that runs emails of its clients. Sounds to me like a bank. Sounds to me like a doctor's office.
Solicitor client.
Well, beyond the solicitor client, I mean, it could be your local bakery shop.
Okay.
My question to you is, do you believe that the Intelligence Commissioner, in your capacity, should be able to make mandatory orders to plant government-demanded technological devices to spy on customers of everyday Canadian businesses without a court order.
Well, let me be, if I look at the, what the minister has to provide to me is listed at paragraph 7, subparagraph 3. If I have an issue such as the one that you're raising, the bakery shop, it will raise in my mind major questions. And I'm just saying that without knowing exactly what would be done, I don't know at the end what I could do. I would like you to know that the job that I have presently in my first year to I had situations that I never thought I would face. Never thought I would face.
I appreciate
and
if I may, I only have about a minute left.
No, I don't want to use your time. Go ahead.
And in fairness to my friends, my liberal friends disagree as to how we interpret the statute. They believe that it only applies to internet service providers. I don't read the statute that way, but I think I should afford them that fairness. I'm curious. I'm not going to ask you over the number of years how many times you've been asked to approve or disapprove an order. But without breaching any confidentiality, are you able to tell me what's the ratio of success of the government when they show up?
Yes, I could tell you that
50-50?
I'll just give you a big picture. Madame de Bellefeuille talked about 14 decisions that I rendered last year. I think they're going to come down to approximately 9 this year. I must have signed close to 50 decisions since I began doing that. And out of that, I would say around 15% of activities were denied.
1-5.
1-5.
So
15%.
So 85% the government got their request.
Not the government, CSE.
CSE, yeah.
And also public safety.
I didn't expect that, but I appreciate your candor. Just to Meta.
Thank you very much, Mr. Baber. Unfortunately, we're over time there. Okay, le dernier MP ce soir.
The last MP tonight, Mr. Ramsey, for 5 minutes. I have a question for Meta.
You wouldn't be able to protect the privacy of Canadians. Are you actually acknowledging that if the law passed, Canadians should close their Facebook and Instagram account?
I don't think that we're suggesting that. I think the concern is that if the law passed, it creates an authority for the government to serve orders on us that could fundamentally break the security guarantees of our or any other subject service
having heard
provider.
what you just heard, which is that there's le commissaire au renseignement that will validate the order, l'arrêté du ministre, and that you have a judicial review that you can apply so that this will go to court. Do you still have the same fear?
I think when we're looking at the legislation, we are hoping for a certain level of legal certainty, not only for ourselves and our ability to conduct our business operations, but also for our users.
I hear you, but I disagree. I think there's a fair amount. There's a fair. I'm sorry. I think there's a fair amount.
Just a minute, Ms. Ramsey. We need to, no, okay, we need to, it's very difficult for the interpreters as somebody who has once or twice interrupted a witness, I've been told, only the ministers. Let's start again, Monsieur Ramsey, avec votre question.
Mr. Ramsey, you go again with your question.
The fear of Meta, they said that there would be a spyware somehow. Monsieur Noël, est-ce que si on...
Mr. Noël, if the minister authorized the installation of spyware, could you turn that down, reject that? Because Meta seems to fear that the minister might abuse his powers. I can assure you that I would very seriously look at that.
Meta, that in that case, you would present to me a document, and if it's convincing, I will certainly look at it seriously and make up my mind down the road. I know what encryption is all about. I know how important it is. If something is tried to circumvent the encryption and open up the channels to other things, well, I still have a common sense. I know what I'm doing, and my intent at the end is to protect the privacy of Canadians, wherever they are.
Monsieur Caputo, comme on dit, I rest my case. Je vais donner le reste de mon temps.
I will give the rest of my time.
Okay, you have 2 minutes and 15
Thank you very
seconds.
much, Mr. Chair. Mr. Green, Meta already complies with the U.S. Cloud Act, which gives, as you mentioned, which gives American authorities the power to compel U.S.-based technology companies to produce data under their possessions, custody, or control, regardless whether the data is stored in U.S. or Canada or elsewhere abroad. Under the Cloud Act, the U.S. authorities can obtain access to Canadians' data through judicial orders served on companies like Meta, and Meta accepts those obligations as a part of operating in the United States. So Bill C-22 similarly requires lawful access based on Canadian legal
If we
authorization.
could just slow down just a shade, please, Ms. Akans,
Okay.
for the interpreters.
Oh, sorry.
Mr.
Bill
Baber's not one to talk.
C-22 similarly requires lawful access based on Canadian legal authorization and judicial oversight, yet Meta has raised significant concerns about Canada's proposal. Can you explain why Meta considers it acceptable for U.S. authorities to compel access to data globally under the Cloud Act, but objects when Canada seeks to ensure its own...
Just one moment here, please. We have a
Sure.
point of order from Mr. Baber.
Very important that if my colleague opposite... I think it's very important that if my colleague opposite is going to put a fact on which she's going to predicate an argument to the witness.
It's not an argument, it's a fact.
Excuse me, let me finish my point of order.
Okay.
Then it has to be truthful and accurate. In one case, it's with the judicial authorization. In this case, it's without judicial authorization. That's the difference.
Well, this
There's
may be
still-
no,
there's still
please.
authorization
Oh, we
here.
were going so well. We're near the end of the night. I know that different people can disagree on different points and what they read into things. So I take your point, Mr. Baber. I've known Ms. Akan to always attempt to be on the up and up. So this may just
Point
be
of order, Mr. Chair. I'm sorry. That was not a point of order. You know that very well. The witness is perfectly capable of responding in that way if that was what the witness feels. And please.
Okay, let's all, everybody. Okay, we are now past. Okay. Yeah, we are well into debate here. Let's ask Ms. Akan, if you could please ask your question again.
Thank you very much. I brought Cloud Act because there are two acts here which are for the same purposes, and in our act we do have some orders too. So I'll go back to my time was still there, right, sir? Okay. Can you explain why Meta considers it acceptable that the U.S. authorities to compel access data globally under the Cloud Act, but objects when Canada seeks to ensure its own law enforcement agencies can lawfully access information under Canadian law to investigate child exploitation, human trafficking, organized crime, and terrorism? And why should Canadians accept a situation where U.S. authorities can lawfully access our data through Meta, but
Again,
Canadian
Ms.
law
Akan, you
enforcement
need to
faces
slow down.
additional barriers? Thank you. That was my question. Thank you. That's okay.
Seconds for an answer.
Okay, my very short answer is that the Cloud Act does not provide for what you're describing, and U.S. law does not have any provision that would allow for the U.S. government, with or without a court order, to mandate providers build an encryption backdoor or otherwise put government surveillance software onto their systems. And that is the primary point of concern with Part 2. The Cloud Act would allow for increased access to communications data under Part 1, and we are supportive with some amendments that Part 1 could move forward, and we would certainly love for Canada to enter a Cloud Act agreement.
And we will look forward to those amendments. I know that this has been a very long 4 hours. Merci aux interprètes. I hope I said that.
Thank you to the interpreter.
Merci au greffier.
To the clerk. And thank you to the members.
Bonne soirée.